चलो। and matter, shortly, any civil matter, it's for the DC, district court. Right? If you happen in any criminal offense like accident, any trouble between the person, as an employer, you are not paid EPF, ETF, gratuity, all under criminal offense, which goes to magistrate court. Right? Then, from the MCODC, I'm not going too much fast. It is up to you to get notes. Notes mean not you don't want to write each and every word from released from my mouth. Get the short note, right? Get the important points. So MC for the criminal, DC for the civil. Okay, if you are not satisfied with the judgment, you can go and say, Honorable Judge, your judgment is wrong. For the same court, you can't go and say like that. If you are not satisfied with that judgment, MC or DC, what you can do is appeal to the High Court. Right? Okay, good morning, participant who joined with the online. Can you hear my voice? If you are not replying for me, it's going to be a loss for you. Really, I don't like for the chat box. Please use your mic and answer because we are learning law. Yes, Chamini, you said you can't hear anything. Now, what is the situation, Chamini?
No, it's okay, sir.
Right. Just now we are started. අර මේ ටියුට් එක ෂෙයා කරනවා මේ ටියුට් යන එක පේපර් එකක්. Okay, I'm just giving a small question on the beginning. Most of your letter of appointment, you can see there is a clause like that. Can you hear my voice to all?
Yes, sir.
Right. Please write down this very small question on the beginning. Most of the letter of appointment, you can see the clause, right? That you may be transferred to any place without notice or without informing during your probation. You got my question? Very simple thing. During your probation, you may not transfer. You may terminate it or extended your probation without notice or without inquiry. Most of the letter of appointment, you can see that clause. Just I am asking whether it is legalized. One. You have to put your answer in one word, yes or no. Okay? You want to clarify about the question more than that? Right, silent mean you got the question. Use the chat box and send the answer, yes or no. Right, now I'm explaining the court procedure. Can you, online people, can you see this area?
Yes,
right.
sir.
You can see.
Yes, sir. We can.
Right. Now, I'm talking about the court procedure in Sri Lanka, magistrate court, district court, and if you are not satisfied about the judgment, you can appeal it to High Court. Right? Then, even after High Court, if you are not satisfied with that judgment, there is a place called there's a senior court called Court of Appeal. So after that, you can see Supreme Court. Now you can understand you can appeal any judgment against MCODC to the High Court. Against the High Court, you can appeal to Court of Appeal. Against the Court of Appeal, it is Supreme Court. එතකොට Supreme Court එකට උඩින් මොකක්ද තියෙන්නේ? Supreme Court එකේ වහලා. හොඳට මතක තියාගන්න කිව්වා කියලා. That means there is no place to appeal against the Supreme Court. It's the final. Right? So why I'm using red color here? If the judgment delivered from Court of Appeal and the Supreme Court is going to be a case law. Right? If the judgment delivered from this high courts is going to be a case law. Right? So what is the importance of the case law? මොකක්ද මේ case law කියන එකේ වැදගත්කම? The importance of the case law is if these senior courts deliver the judgment today, you can use it as a law from today onwards, any forum of the law. That means even in the same court, any other court in Sri Lanka, any other court, from BC, MC to Supreme Court. Any other place where law is implementing, maybe Labor Department, Labor Tribunal, Police Station, Foreign Employment Bureau, wherever the law implementing, you can use it as a law, not passed from the Parliament, but interpreted by the Supreme Court. Higher court, I can't say only Supreme Court, even from the Court of Appeal, it's a case law. Anything you want to verify regarding that small thing? The difference between case law and written law, the importance of the case law. Here?
I think Hindi law is not really so highlighted for the point. Like he is dragging the case, and we are going to make one statement.
One?
Statement so the what is not covered by the law.
Of course, of course. That is why case law, right? Now he's very correct, right? Now sometimes the meaning of the law is not clear from the written law. In that situation, the court is interpreting, and sometimes courts giving new interpretations. That's why it's a law. Now, I am showing today with the case law and how important that case law for us. Without knowing only written law, we cannot run. Right? That is some sort of introduction about the case law and theory law, right? Now we are coming to our main topic, labor law, right? Now, in case of labor law, how it build up? Now, if you go to our house, our personal thing, there are some linkages, agreements. What are those things? I'm not talking labor law. In your house, there are some linkages, liabilities, agreements. Forget about all those two words. There are some agreements in your home. What are those things? In your home. In your home, there are some agreements. How do you agreement? Right? So in case of marriage agreement, you are giving an oath. Right? Adin pasu, me kantawa and pinuma kantawan. Adin pasu, me kantawa, magi bindu vasin baragada, emanatan. Adin pasu, me purusya, mage, swam purusya vasin baragada. After giving that oath and signing and having the two evidences, agreement pure law. Right? Through partition of that agreement, husband and wife. If any person violated that agreement, what happened? What happened? What do you know? According to the law, if any person violated that agreement, another party can go to the DC and make the case against that the person who violated, saying you are breaching the contract, you are breaching the agreement. This is my loss. Pay the compensation and ask for the compensation. That is the civil agreement, right? In your home. Okay. In case of marriage agreement, if you are going to the courts, who is coming to support you? ඒ වගේ වෙලාවක divorce එකක් දාන්න උත්සාහ කරනවා නම් මට උදව් කරන්න ඉන්නේ කවුද? ඈ? අපි ඉතින් කිව්වොත් උමත් වෙනවා ඒක උදව්වන්නේ ජොබ් එක. ඒක උදව්වන්නේ ජොබ් එක ඒක අපේ. යා ගාලි කිව්වොත් ඒක උදව් කරන්න ඉන්නේ. හා? ඔයගෙන් තමයි එමනේජින් එමනේ come with you to the courts and support you. Who is the person? Agasta parent to the Mogura. Normally parents are coming. They are not coming up to do that. You and Bablo Korean, Nepal, you know, Muslim country, and Bono Korean. Name of your parents are in the Mokaka action. Mokakatne. If you were there. යාළුවෝ ඥාතීන් ආවේ නැත්තම් මොකද කරන්න පුළුවන්? ඒත් මොන මගුලක්වත් කරන්න විදියක් නැහැ. තනියෙන් බෙරේ ගහගන්න. That is the situation of that agreement. But if you have an agreement with your employer, the two parties going to be employer and employee. Agreement between employer and employee. That shows an agreement. It is not like a civil agreement. The important reason is this is labor agreement covered by more than 50 labor acts and supported by government organization, labor department. මේගොල්ලෝ අනිවාර්යෙන් අනේ එන්න කියන්න ඕන එනවා. Right? And you can go and make a complaint even without a lawyer to LT. Labor tribunal. Right? So that is the power of the agreement, labor lawyer. Right? That is the power of the labor lawyer. Right? Then once you make the labor law agreement, you are having a big power, big cover under the law. Right? That means you are having employment. Under the labor law, you are an employee and you are having employment, right? You are covered by the labor. Now we'll see if you are having a labor law agreement, what are the, you are having employment, that means you are having employment, then what are the types of employment? So please write down the topic, types of employment. Employment types. Now, most common type that we know, most common type permanent, right? Permanent employee. Permanent means that the particular person, particular employee there will be a end date, that is retirement age. That he's having the particular person having an expectation and getting a permanent position. His contract may be over at the age of retirement. Right? After having that letter of appointment, but the particular employee having that expectation. Expectation. Is it legalized expectation? Yes, because there is an agreement between his employer. Therefore, we can call it legitimate expectation. නීතිමය අපේක්ෂාවක් තියෙනවා යාට මට විශ්‍රාම යනතෙක් සේවය කරන්න පුළුවන් කියලා. It's a expectation. Legitimate expectation. Right? Now, we take it as date wise, huh? Hey, first employment type is permanent. His legitimate expectation is to work up to retirement age. That's only expectation, right? He joined the organization January 1st. He joined the organization January 1st under permanent category. Now, the employer said, till 6-month period, you are under probation. So, how the probation given? When will be the probation ended up? 30th of June. So, this is probation period. This is probation period. Right? Now, what the employee's expectation is to work till end of my retirement age. Right? But the employer says you have to start with the probation period, that is 6 months. Right? Now, in that letter of appointment, from this letter of appointment, you can see this clause. Right? Then, June, when you are going to extend the probation period normally, June 20. If you want to extend the probation period, this person, when you are releasing the letter, මෙයාගේ probation එක දික් කරන්න ඕන ඩිල්ම ගහන්නේ කවුද? දන්නේ? ඉතින් නිකන් රෆ්ලි හිතලා කියන හරි දෙන්නේ නේ. ධර්මයක් නේ. කවුද ගහන්නේ? ඈ? මේ ඩිල්ම ගහන්නේ. කිසිම chance එකක් නැහැ ඒක. one month time. ඒක පොඩි chance එකක් තියෙනවානේ. ඒ කියන්නේ ඔයාගේ දිනේ මොකක්ද? ඈ? 31st of May. 31st of May. Probation extended up to, say, another 2 months, right? That means July, August, it's extended up to 31st of August. Now, we know who is permanent employee. That means he is having a legitimate expectation to work till end of his retirement. But initially, there is he has to follow probation period. Is the probation. Now, who is the probation? According to the Termination Act, according to the Minimum Retirement Age Act, there's an interpretation. According to the Minimum Retirement Age Act, there's an interpretation. Today we are not learning Minimum Retirement Age Act, but I will show the only interpretation. Do you know Minimum Retirement Age Act? එමයක් අහලා තියෙනවද? according to the Minimum Retirement Age Act, there is an interpretation. This module you will learn the act, but today I'm showing only interpretation, right? It says who is probation. So according to that act, probationer is the person who worked initial 180 days. Initial 180 days, right? But there is some hidden things on that interpretation. You will see it now. That's why the court has to interpret it. Now today I will teach you both the written and case law regarding the probation, right? Now the most important thing I told you earlier, right? There is a legitimate expectation for the person who joined the organization to work until he reach the retirement age. That is the expectation. Right? මේ පුතා මෙන්නකොට මම මේ ඕපන් කරේ ගන්නේ මම දැන් ඕපන් කරා ගන්නේ
සයිට් සෝදාගන්න ඕන
නෑ නෑ මෙහෙම මේ මේක නැතුව මේ කම්පියුටර් යන්නේ කොහොමද
කම්පියුටර් ඔකේ මේ
මේක හරි thank you. Now පිටිපස්සට පේනවද? Can you see it clearly? Right. Now this is the act is Minimum Retirement Age Act of Workers, that is 2021 number 28. Right? Act number 8 to year 2021. Go for the interpretation of this act. And normally what I'm doing is I'm showing original act. Always I'm showing original act because it is more benefit for you to read it and understand in later on. Right? Otherwise I could have taken it to the presentation and do it. But I think this is the best thing. Right? Now this is the interpretation regarding the probationer. Probation worker. Right? Please read it yourself. Probation worker means a worker, again try to understand there's some hidden words. When you are reading an act or section, at least read it 5 times. Each and every word is important. You can choose the pudding around right? Means worker who works for a period for not exceeding 180 days, within which such period the employer has the sole discretion. Sole discretion to whom? Employer, to decide whether such worker is suitable for a particular position, and if not, may decide to extend such period for a maximum period of 180 days, that means 6 months, and does not include a worker if such worker has been employed in the same post or perform same work previous to any contract of service with that employer. Can you find out the hidden words here? Hidden meaning here. දෙපාරක් තුන් පාරක් කියවලා මට කියන්න බලන්න මේකේ ඔයගලන්ට අහුවෙන සංගවෙන අරුත Online people, can you see the screen?
Yes, sir. It's visible.
Okay. Please read this section and tell me what you can understand from this. Regarding the probation. What is around?
So it is, it is more, it is more than that. And if employer is not satisfied with the his position and the work, so there he can still another duty. That is matching. I think
Then is it this one is legalized? What you can understand from that law? That means he can terminate the employee. If the employee is not satisfied.
here they are not looking for mention about the termination.
Not mentioned about the termination.
The employee, but all authority is given by the employee.
So all authority.
It's free, that's it.
Kita dan uang kira kita boleh ada Very good. Very good. Now that's a good answer, right? It is not 100% clear. As you said earlier, right? When the law is not 100% clear, then the court comes to the front. There is another act, notice under the labor law, but I will just inform, not under the labor law. It is Interpretation Act, right? Those who are interested in law, you can mention, but not included, not according to the, not under the labor law. It used by the courts, not relevant to the labor law. Just informing who are interested in law. It is Interpretation Act. According to the Interpretation Act, there are two rules. Again, I want to say this is not labor law. I'm just telling those who are interested for the law. According to the Interpretation Act, there are two rules, right? Mischievous rule, golden rule. The two rules says court should give maximum support to the act, maximum goodwill for the act, not to do any mischiefs. That is the theory of the Interpretation Act. You don't want to go more further, it is not labor law. I'm just telling those who are interested for the law, right? That is how the court is interpreting this type of situation. Now you are clear. In case of that person who extended probation period, he has to go to the theory law. It is this one. But again, some hidden thing not clear. Go to the course. Take the case law. Right? මේක අවශ්‍යයි ලියාගන්න. ඇක්ට් එකේ තියෙනවා. ඇක්ට් එක ඩවුන්ලෝඩ් කරගත්තාම බැලුවා. නමුත් අවශ්‍යයි ලියාගන්න ඕන ස්ක්‍රීන්ෂොට් එකක් ගන්න ඕනයක් කරන්න. But if you are doing the labor law diploma, remember all laybacks with you. All laybacks with you. You can do very well. From where you can get it? Very simply go to Morella publication or go to Polden Border. What is that? Government publication bureau. Right? So both places you can get it. Those tax are very expensive. 50 rupees, 20 rupees, 30 rupees. Like that. Right. The traveling cost expensive වෙන්නේ. Right? Or go to the website. Website එකෙන් ටිකක් අමාරුයි. පිටර දඟලන්න ඕන නැහැ මෙතෙන්ද ගියාම ටිකක් අහුවාම රුපියල් 20යි ගියේ 30යි ගියේ රුපියල් 10යි පැත්තට රුපියල් 8ක් තියෙනවා. ඔක ගත්තා පරිලීසි. හරි. තමන්ට ඕන විදිහට අයිඩියා කරලා මාක් කරලා කරු දාලා ඕනේ අතට ගියා. ඔක්කොම ලේබර් ඇක්ට්ස් ටික ගන්න අරගෙන තියාගන්න. Right. Now this is the theory law regarding the probation worker. Now again, I want to say you, this particular person having a legitimate expectation to work until his retirement age. That is his legitimate expectation because of the letter of appointment. There is a contract, there is a legalized contract between his employer. Right? Now we'll see what the case law. Pretty well said, name. You can see it. Right. As I told in the beginning, the case law coming from the Honorable Court of Appeal and the Supreme Court, this from Court of Appeal, right? Where another important thing is when will be decided. That means when will be that judgment? When was that judgment? Very old. Decided date. කොච්චර පරණද මේක? අවුරුදු කීයක් පරණද? මේ තියෙන decided date එක? තීන්දුව දීලා මාස කීයක් වෙනවද? අවුරුදු කීයක් වෙනවද? That is very latest one. Latest one. Right? Now, if you are following the label, another advice is always touch with the latest label or judgment. Right? How can you do it? Go to the websites, go to the articles, or contact your people who know that this area. Anyway, try to get it. If any label or judgment delivered in yesterday, I know. Right? That should be very important thing. Right? What is because case law day by day develop in the law. So we must know it. Right? Now, what the situation of probationer according to that act? That means theory law. Right? It's a sole authority. What is that word? Anyway, it's there. It's a sole authority to the employer to decide. Yeah. Sole discretion. Right? That means employer can kick off the employee even out of the ground. Just like a football. Sole discretion. Right? Employer can extend the probation of the employee without notice, without inquiry. That's the situation. Right? Some employers feel like that. Some are evaluated. Non hardly. That ඒක විසාරි පස්සේ ඉන්න එක දාන්න. වයින්ද? තියෙන අසංගලදී තීරණයක් දාලා රෙඩයිටින්. වලට අසංගලදී. They feel they are a king of their own organization. Yes, king, we accept it, but not the king for the country. Right? He is under labor law. There is an employee-employer agreement. Not like marriage agreement. Okay, marriage agreement or කරනවාදී තනියෙන් වෙන දෙයක් කරගන්න ඕන. හැබැයි it's not like that. More than 50 day backs. And the labor department and the labor tribunal. Those things are there. So then in that situation, the employer feels he can do anything, and because of that, employer extended the probation. That example. We'll see this one. තේරුන්නේ නැද්ද? මොකද ප්‍රශ්නේ තියෙන ගන්න. මෙහෙමයි. මගේ ක්‍රමේ දැන් සමහරව හිතනවා අනේ මේ ප්‍රශ්නේ අහන්න නිකන් ලැජ්ජයි වගේ අනිත් අය hina වෙයිද දන්නේ. අනිත් අයට hina වෙන්න බෑ නම් ඕනයක් කරගන්න කියන්නේ. තමන්ගේ ප්‍රශ්නේ තමන්ට. Right? Your question for you. ඒක මෝඩද උගත්ද කියන එක ඒක අනිත් අයට වැඩක් නැහැ. ඔයාට ප්‍රශ්නයක් නැත්නම් ඔයා බය නැතුව අහන්න. That is why you are coming here. Don't try to ask anything, any question or any clarification. මේක ඇහුවොත් මේ ලෙක්චර් තරහ වෙයිද? මොන මගුලට තරහ වෙන්නේ? කියා දෙන්නේ මං ඇවිල්ලා තියෙන්නේ. Right? මේක disturb නෑ කිසිම disturb ගන්න නෑ. Yeah. එහෙම නෙමෙයි තියෙන්නේ. එහෙම නෙමෙයි තියෙන්නේ. ඒ කියන්නේ මේ දැන් මේකට අනුව පුළුවන්. මේකට මම තාම පුළුවන් කිව්වේ නෑ. මේකට අනුව පුළුවන් කියලා විතරයි කිව්වේ. හැබැයි මම පටන් ගනිද්දි කිව්වා ලෝ එකේ දෙකක් තියෙනවා.
ඒකේ කියලා නැහැ කොහොමද මොකද්ද කන්ඩිෂන් මොකද්ද රීසන් අවුට් කරනවා
ඒ මොකුත් නැහැ. ඒක තමයි මම කිව්වේ අපිට ලෝ එක වෙරි කරේ. ඒක තමයි මම කිව්වේ අපිට ලෝ එක ඈ නෑ නෑ පොඩ්ඩක් ඉන්න තාම කේස් ලෝ ඉගෙන ගත්තේ නෑ. ඒකේ වනලා නෑ. ඒකේ හොඳට පිරිසුදුට අත ගාලා කියලා තියෙන ගානට. තාම අපි ඒක කරේ නෑ. රයිට්. කොච්චර වැරදිද මම කරන්නේ. මොකද බලන්න ඉන්න මම තේමනු. හරි. මම දැන් කීකරේ. අපි හිතේ ගේම් all of you can clearly understand what I am saying. මම කියන දේ හරියට වදිනවද? Well, this is my system. Presentation slide එකක් දාලා උඩ කියව ඉන්නේ මම. හරියටම case එකක් you know how you have to go there. Uh, here you can see the hero. Please go and have your PM come up. How is your feet? How is your height? 6'3". Let's for him. label hari lohan kain ko hari kira kira tu. You know that. What kira kira? Siapa tu? Ini kan label hari lohan. Okay. So, meeting is kira tu. Draft meeting. Eh? 6 feet and 3 inches. We discussed about the height. It's very important. Very important. Right. Now we understood the theory law. Also, we can have idea that sometimes we are getting difficulty to getting a 100% picture. So we'll go to the case law. Right. Now this is the case decided on last year. Do you know how to read the case? කලින් ඉගෙනගෙන තියෙනවද නැද්ද? නැත්තම් නෑ කියන්න මම කියලා දෙන්නම් ඔය ඉස්සෙ. ඈ? පුළුවන්?
No.
No. Right. Now this is from Court of Appeal. And this is a writ case. Normally, what do you mean writ? Any appeal against the government officer's decision. Challenge the government officer's decision. If you are not satisfied about the decision of the any government authority, the one way of challenging, there's another ways. One way of challenging is the writ. And you can see here the government, who is the government officer here? Labor Commission General, right? This company as a petitioner challenging the decision of the Labor Commissioner General. Way of writ. In case of judgment, the things that you have to keep in your memory: Court of Appeal, this reference number, and one of these parties is enough. මේ ඔක්කොම ටික මතක තියාගන්න ඕනේ නැහැ, right? Court of Appeal, right? මෙන්න මේ විදියට. Court of Appeal, writ, number, and the one of the party. මේක කියන්න පුළුවන් Court of Appeal writ 227/2022 Embody Trading Private Limited case එක. ඔය ඇති. It is good if you can say it is decided on this day. If you can, otherwise no problem. Right? Now we'll see the case. That's the important thing. Please read this para and I will teach you. Read this para. He is the probationer. Join the organization And while he was in the probation period, you can get the screenshot, but don't share it because I have already highlighted and did something. This is a court of appeal judgment, right? I did only for teaching. I am not a court of appeal judge. You can get the screenshot, but don't share it, only for your study purpose. Only for your study purpose, don't share it. Right? Right. Now, he's under probation. And during the probation period, something happened to him. That means he was terminated, right? Then the relevant employee having an agreement between his employer to work until his retirement age. Now, what happened? During the probation period, he was terminated. What is the power for the employer in this situation? Letter of appointment. Right? He said, but there is a clause like that. There is a clause like that. By using that power, he has terminated the employee, but employee is not satisfied about that. I told you, not like a civil agreement. If there's a civil agreement, you have to do it in your own. But in this situation, more than 50 laybacks, not only that, Labor Department and Labor Tribunals, all those things, all those institute there. So employee came to the Labor Department, made the complaint. So after the inquiry of the Labor Department, the Commissioner General ordered to pay back wages for him. Now, petitioner company not satisfied about that order by the Labor Commissioner General. Under the powers of the Labor Commissioner General, he has the right to give that order. Right? He has the right. But if you are not satisfied as a company, you have a right to appeal against it. Right? Okay, so another way is, if you obey that order of the Labor Commission and pay the amount for the employee, what happened to the company? You will matter. What have you What have you right? And when Mudala given a ප්‍රශ්නේ ප්‍රශ්නයක් වෙන්න පුළුවන්. Because the worst scenario is losing the image of the company and going to be the bad example, bad image for the other employees. Or no one is choose, right? Right. Therefore, now we'll see the dates. It is mentioned the another act called TEWA. That means Termination of Employment of Workmen Act, right? It will be with you in near future. But today I am teaching only one section of it, right? Okay. ඒවා section 2 1A at number 45 1971. Right? Section 2 1 section 2 subsection 1A at number 45 1971. The entire act you will learn in this under this diploma. Today I mentioned only one section. Right? Act number 45 1971, that is Termination Act. Section 2 subsection 1A says if the employer wants to terminate the employee, what short form right? If any employer wants to terminate the employee, section 2(1)A says you have to get the prior written consent. Prior written consent. It is in section 2(1)A of the Act number 45 1971. Three important wordings: prior written consent. If the employer can get it from the employee, he has the power to terminate. Three wordings: prior written consent. පූර්ව ලිඛිත කැමැත්ත. දැන් කොහොමද පූර්ව ලිඛිත කැමැත්ත ගන්නෙ? කියන්නේද? කොහොමද ගන්නේ? උට එන්නේ. හලෝ. මේක ප්‍රීඩම් කියලා කියන්නේ. ඉන්නේ. මම ඔයාලට 21යි 22යි හතර දෙන්නා. කොහොමද යෝග දෙන්නේ? ඔකට දීපුවා. දැන් මෙයා කියන්නේ මෙයා හදනවා වගේ. මම මෙයා උදාහරණයක් ගත්තේ. I just take as an example. That is how HR people addressing the employees. මාටි කිස්පෙකයි. කිස්පෙකයි. යටිවිසකයි කොහොමද හදන්නේ? හදන්න දෙන්න කොහොමද දෙන්නේ? right? වාදින්නකො ලියුමලිලා අස්සෙනවා වගේ. Prior written consent. හරිද වැඩේ? හරිද? ඒක consent එක. මෙන්න මෙයාගේ influence එක. ඒක consent එක නෙමෙයි. right? ආව් ලියන එක මම පෙන්නන්න නඩු ඉදුත් එක්ක. ලියන එක පෙන්නන්න දැන් නඩු ඉදුත් එක්ක. ඒක තමයි මතක් කරේ. දැන් මෙයා කරන්නේ කොහොමද? කමිෂනර් ජෙනරල්ගේ කන්සෙන්ට් එක වාට ගන්න බෑ මොකද වයිෆ් දීලා ඉවරයි. 2(1)B මම කියලා දෙන්නා ඊළඟට. මොකක්ද ගොඩක් අය පටලවා ගන්නවා. කමිෂනර් ජෙනරල් කන්සෙන්ට් එක කියලා. ඒක වයිෆ් දීලා ඉවරයි කියලා මට කියන්නේ. හැබැයි කමිෂනර් ජෙනරල්ගෙන් ගන්න දෙයක් තියෙනවා. 2(1)B මම කියන්නේ. හරි? ඊට ගානේ 2(1)A කියන්නේ බෑ. right? දැන් මෙයා ගන්නේ කොහොමද? මේ අර විදිහින් මේ ගත්තේ. ඔය ලියුම. මෙයා ගන්නේ කොහොමද? ඔය මෙහෙම සම්මුතිත හොඳ හිතින් කියන්නේ අයින් වෙනවා නැත්නම් සම්මුතිත රිමාන්ඩ් එකට යන්න වැඩි කරනවා. ඒක කොහොමද දේවල් වෙන්නේ මොකක් හරි කොටපටයක් වෙච්ච නිසානේ. නිකම්ම අයින් කරන්නේ නැහැ. දැන් වැඩි හම්බෙන්නේ. ඒ මොකද්ද? අරක ඉන්ෆ්ලුවන්ස් මේක ත්‍රෙටන්. කොහොමද කන්සෙන්ට් වෙන්නේ? ඒක කන්සෙන්ට් එකක් නෙවෙයි. right? මෙයා ඒක කිය අක්ෂර විදිහට කියන මෙහෙම. මේ වාග්ම හොඳ සර්විස් එකක් අරගෙන. යොපේක කරලා. ආයි කරනවා. එයා මොකද කරන්නේ? Giving promises. It is not a consent. Influence threaten, promises, not the consent. ඔය ටික ඇක්ට් එකේ නැහැ. Case law වල තියෙනවා. Yes.
Producer create very good. Very good. Discuss करना चाहिए. आप लोगों ने opening
Excellent. Excellent answer. ඒක තමයි මම ඉස්සරහ තියා දෙන්නත් තියෙන්නේ. You are going excellent answer. Very good. Very good. Right? That is the proper procedure which is not followed by so many organizations. If you are following, excellent. Right? Now, the way of termination, even in the probation, you have to get the prior written consent. Another way of termination, as she said, not the Commissioner General consent, it's already given. Approved. That is section 21B. ඔය විදිහට මතක තියාගන්නවා. ආයි පටපාඩම් කරන්න දෙයක්වත් නැහැ. විභාගේ දවසට ඇවිල්ලා අතරම වෙලා ඥානපටි ගහන්න ඕනෙත් නැහැ. ඔවා ඔළුවේ මතක තියාගන්න. මෙතනින් එළියට යද්දි මගේ ලෙක්චර්ස් වල හොල පුරවන්න එපා ඔළුව පුරවලා. මම ඒ පිරවෙන විදිහට තමයි කියලා දෙන්නේ. Right? In the, huh?
also benefit. Commissioner General for examination and number one. The four case was after appeal to be wonderful. So yes, Mama, you don't know.
Ah, good question. Now he is asking, when there's a disciplinary case going on, you need to get the approval from the Labour Commissioner to terminate the employee. Correct me. Termination Act number 45 in 1971 very clearly says, if there's a disciplinary matter, act is silent. Right? But how can you say he's theft? What is he in the government? ගොඩක් වෙලා නගුරු හීන දැකලා කියන්නේ. How can you say he is a thief? It's on the law. Until you prove you are not guilty. නීතිය ගන්න ඔයා වරද කරුවේ කියලා ඔප්පු වෙන තේ වරද කරුවේ කියලා. ඉඳ අරු හොරා කියලා කියන්න බෑ. Then initially in the company premises you should do a impartial inquiry. That is different than any criminal offense. It is going on, but no judge will be ordered for the company to terminate or not to terminate. Don't expect from the courts. While the say if there is any criminal offense by the employee, yes, criminal case is going on. While it is going on, no need to wait till end of that case. While it is going on, you can have your own case in your company premises. That is the case regarding your employee-employee relationship. Regarding your letter of performance agreement. But in the courts, that's a different case. Under the criminal law, whether this person guilty for this particular criminal offense or criminal offense or not. There are two cases. As a company, no need to wait till end of that case. You yourself do the disciplinary inquiry and find out whether this person is guilty or not. Because court will not order to terminate. A magistrate court. Right? It's up to the employer to do the inquiry and find out whether this person is guilty or not. Right? It's your own case. But it should be very impartial. I mean, from the discipline you will learn it in this course. It should be very impartial. Domestic inquiry. Oh. Why? I told you, no, that will be order to terminate the employee. Answer. For the domestic inquiry. That is domestic inquiry. The criminal case is going on the phone. Why not? Must be outside. Independent employer. Otherwise, you will learn it with this course. Otherwise, it's going to be a rule of violating the rule of natural justice to do the inquiry. Inside person. Of course, in the domestic inquiry, there are two steps. First thing, initial investigation. It will be done by the company. But the second part, independent inquiry should be done by the outside person. There is a lesson for your module, diploma, discipline procedure. It's a module, not module one. Later on you learn. I just සමහර මෙතන කියනවානේ. මේක ඇතුලේ යූනියන් බෑ. පාපෝවා මේ ගෝස්ත ඉගෙන යන්න. සමහරට ට්‍රේඩ් යූනියන් සහයල්පි මම කරන් ඉඳ තියෙනවා. එහෙම කිව්වොත් මොකෝ කියන්නේ? මේක ඇතුලේ යූනියන් බෑ. හරි අවුලන්නේ. දැන් පොඩි හින්ට් එකක් දෙන්න ඔයගොල්ලෝ. You will learn it later on. Read the Constitution, Chapter 3, Article 14(1). Constitution is the superior law of the country. Read the Chapter 3, not 11 today's lesson. For him, and those who are going to learn the law, right? Read the Constitution, Chapter 3, Article 14(1)(a). You will learn it elaborately during this course. දැන්ට කියවලා බලන්න මොකක්ද තියෙන්නේ ඔගේ කියලා. Article 14(1)(a). Right. Now I explain only one section of the Teva. Now, according to that, Section 2(1)(a) says consent of the employee. 2(1)(b) says approval of the Labor Commissioner General. Now, what the case, right? He was appointed. මාත් එක්කම යන්න යන්. ඔයගොල්ලෝ මේක සටහන් කරගන්න. He was appointed as an employee when March 8, 2021. He was appointed from his letter of appointment as a probationer. මෙහෙම short form එක ගත්තා නැති. March 8. Right? Then his probation period 6 months. Right? Up to September 7 of 2021. That is probation period. This clause is in his letter of appointment. මේක යාගේ පත්තිය ලිපියේ තියෙනවා. දැන් මේ දේ හරි නේද කම්පැනි එකට. ඔන්ලාට ගැහුවපයි එක්ක පිටතනේ වෙන තැනක නැත්නම් පිටතනේ එළියට. If the employee may be another place in the ground or out of the ground. I will close it. Employee has already acknowledged letter of appointment by signing. පත්තියේදී අසං කරලා දුන්නා නේද? එදෙදි කීයෙන් කියවල බලලා අසං කරා? මං අහන්නේ ආවා. ඕක කියවෝ ඉන්නේ වෙනිටික් කරලා මේ පත්තියෙන් බාර ගත්තා නම් මම ආතිලා වගේ. එනිසා කියවෝ හිටියේ නෑ. අසං කරලා දුන්නා. මොනවද කියවද කියලා අදවත් දන්නේ නෑ මට. That is the real picture. Legal picture එක මොකක් වුණත් that is the real picture. Right? Okay. Anyway, I don't know whether this particular person with the letter of appointment or not. Anyhow, his probation up to this day. However, what happened? Two months. Then what is the date? Up to 2 months. This is probation. This is extended probation. Right? And according to that, the extended probation will ended up in number 6, but he was that's another point, right? But he was terminated on uh, 31st October 2021. Terminated. October 30 එක මෙයාව terminate වෙනවා. No inquiry, no notice. He was terminated. Now he was terminated during the extended probation period. Right? facts ටික ටක් ගාලා ලියාගන්න. වෙන මෙච්චර. මේකේ තියෙන ඔක්කොම ලියන්න ඕන නම් මෙන්න මේ ටික ලියාගත්තා නම් ඇති. Now you know the story.
One question, the probation period recognized required intimation should be done.
Yeah.
Duration for it.
Extend. Another, the act clearly says another 180 days.
No, to inform.
Very good question. මම ඒක මේකෙන් පස්සේ කියන්නේ මම කියන්නම්. මේ දැන් කියන්න. To inform. Now, you as a HR manager, as a company, you recruited the employee. Right? අපි එකත් මේක මාස විදිහටම ගමු. Right? You recruited the employee, say January 1st. Right? The probation may be 6 months. When will be the end of probation period? June. Oh, ඉතින් කතා කරන්න ඕන. 30. Now you want to extend the probation. When you are going to issue in the letter for him? දිනයක් කියන roughly. දැන් මෙයාගේ probation එක extend කරන්න ඕන ඔයගොල්ලන්ට company එකට. ලියුම ගහන දිනේ මට පොඩ්ඩක් කියන්න. HR නේ කියන්නකෝ. ජුනි 15. එදා තමයි extend කරලා ලියුම ගහන්නේ. You are issuing an extension letter June 15. Extension letter. Right? Then January, February, March, April, May. And June 15, you are issuing it. Now tell me, you recruited him January 1st. End of the January, you pay him. End of the January, you pay that employee, whether it is a salary or charity. සේවකයාට ජනවාරි මාසේ ගෙලේ පින් පඩියක්ද පඩියක්. පඩියන්නේ. පාර යනට ගෙවන්නේ නැහැ. පාර යන මිනිස්සුන්ට පඩි ගෙවන්නේ නැහැ. පඩි ගෙවන්නේ සේවකයා. If he's an employee, you paid the salary. What's the action you taken regarding him to measure him, to evaluate? If not, you pay the check. තුම ගානේ මාසේ පඩි දෙන වෙලාවෙවත් ඔය ඇක්ට් එකේ නෑ මේ නඩුව මං ඉස්සරහට යද්දි ලස්සනට කිව්වා. So he certify about But that's right. That is the presumption. That's the presumption. That means no mistake. Then how can you extend the probation? Reading. You can do it daily, it's best part. It is not practical. Right? If you can do it weekly, it's also good. But practically, you may get in difficulties. But end of the month, you are paying salary for it. So what are the action you have taken about that employee to check his reaction for the company? මොනවද තියෙන ක්‍රියාමාර්ග? මේ ජජ්මන්ට් එක මම ගත්තේ ප්‍රොබේෂන් එක ගැන හොඳට කියනවා. Then it's okay, no problem. Very good, very good. That's what you need. That's what you need. Now, make judgment එක පස්සේ බලන්නකො. It's the duty of the employer to train him, check him. Duty of the employer to train him, check him, evaluate him, and inform him if there are any mistakes. That is the duty of the employee. Make a වෙන්නේ. So what is happening in this matter? Right? You paid January salary, February, March, April, May. No interaction with him. That means during 5 months period, as an employer, you accept that his performance are good. Then how can it bad June 15? That means you are having a cheated target. You are in a bad image, bad faith. For what? Extend that his probation and avoid the beneficiaries he will enjoy after probation. එයාගේ beneficiaries වලට වැඩේ දෙන්න මේ ගහපු අට්ටාර පිළිගත් තමයි මේ ජූනි 15 නින්දෙන් නැගිටලා ලියුම ගියා. ඊනියක් දැක්ක ජූනි 14 වෙනිදා රාත්‍රියේ ඒ අනුව ජූනි 15 උවා තමයි උසාවියේ HR එකට අහන්න යන්නේ. නෝනා ඊනියක් දැක්ක 14 වෙනිදා රාත්‍රියේ එන්න 15 වෙනිදා ලියුම ගැව්වනේ. එහෙනම් කොහොමද මොකක්ද පදනම? මාස 5ක් පඩිගමේ කොහොමද? ඒවනකම් එයා හොඳයි. යුනි 15 නරකුනේ කොහොමද? Okay, if it is there is a clear argument for you. If it is so, in the very first January, we inform him these things parts are very bad. You have to develop that. But you can't just say that. That's right. And inform him to how to correct it also because he is a probation. Aware him how to correct it because he is a probation. Right? Inform and aware him how to correct it. That means now you are mentioning yes, Europe. That means he is good. But after payment, he is good. අර ප්‍රශ්නාර්ථකේ වාචික වෙනවද කිව්වේ? වාචික. ඉතින් ඔය තුන්වෙනි එකක් හොඳ පැත්ත වාචික කියලා තමයි ඉවරයි. අපිට ආවා මොකක්ද මුස්ලිම් අක්ෂරලා ගන්න ඕන නම් මාසයකින් පස්සේ දැන් මේ මාසෙ ඉන්න එකක් කරනවා කියලා. හොඳයි කියලා කියනවා. ඒක ඇවරේජ් කියලා කියනකොට ඒක මාසයල කියලා අයින් කරන්න ඕනේ. ඒකට අවබෝධයෙන් තමයි ඩිෆරන්ස් ගන්න පුළුවන්. මාසාවේ පුළුවන් දෙකට මාස තුනක් පස්සේ හොඳයි කිව්වා. හොඳයි කිව්වනේ. ඒක ඇවරේජ්. ඇවරේජ් කියන්නේ හොඳයි නරක නෙමෙයි. අර ඇවරේජ් කියන කෑල්ල එයා කාණ්ඩ කරලා හිමින්ද කියලා. නරකයි කියන එක ලියුම ගහුවා නම් වැඩේ ඉවරයි. කියන්න ඕන නම් ඉන්න කියලා කාණ්ඩ කරලා පාඩවක් නැහැ ඉතික තාක්ෂණය පුරුද්ද තමයි. ඒක කාණ්ඩ කරලා ඉන්න කියලා. ඊට පස්සේ ලියුම ගහනවා අඳුරට. ඒකත් වටවල ගන්න. Verbal warning පුතා the main issue is verbal warning. You are getting so difficult to prove it in the court. වාග්මොතේ verbal warning කියන එක so how to any how some way to prove it. And use the copy. And later on what happened? He got the court. He said, the madam says to develop this field. I have developed it. But now madam is saying another thing. That day, it is not the picture. So it is Karakan value. Right? Right? Voice recording, CCTV, everything you can put it as evidence, no problem. Because the Act number 14 in 1995. Evidence, අනිකත් ඔන්න හොඳයි ඔහු ප්‍රශ්න අහන එක. ආයි ගනින් දරවලස් කාලා මේ ලැබගත් පොයින්ට් එළියට එනවා. අද මාතෘකාව අදාළ නොවුණා ලැබගත් කරුණු එළියට එනවා. Can you take evidence as a evidence voice recording no CCTV? Answer is yes. What is the legislation? Act number 14, 1995. Evidence special ordinance. Act number 14, 1995. Evidence special ordinance. අර ඔයගේ අහන්නේ කොහොමද? ඒකට මාතෘකාවට අදාළව අද දවසට අදාළ නොවුණත් වැදගත් කරුණු මයි කටින් එළියට. දැන් දැන් අනුපය අංක දානවා. සාක්ෂි විශේෂ විධිවිධාන පනත. ඒක අනුව ඕනම ඔඩියෝ වීඩියෝ රෙකෝඩින් එක එවිඩන්ස් විදිහට whether it is civil or criminal court, you can apply. Sakshi, Vishesha, Vididana, Panaka. Evidence, special ordinance, number 14, Act number 14, 1995. දැන් ඔහොම කිව්වට පස්සේ ඔක සාධාරණ කරන් ගිහිල්ලා ওই පනත අරගෙන කියවලා බලන්න. right? Right. That is the failure of the employer. No feedback for the employee. And only after 5 months, employer saw a dream. Based on that dream, probation extended, completely unfair. Right? Right. Now, according to this case, he was terminated during the okay. That is the date. The date is now if you evaluate properly, right? If you evaluate properly, if you follow a proper procedure, right? That means at least once a month, right? If you did this evaluation, aware the employee about the weaknesses. So after sending all these documents, all these efforts by the employer, if the employee is not satisfied, very simply, and even June 30th, you can give the extension, no problem. Because you have taken all the measures to not to terminate him, you are off. If you go to the courts, no problem. You can show all these documents. We have done our maximum, our best to develop him. But he is failed. Then the weapon with you can use anytime. Right. Now, once you go through this case, all answers are here. That's why I'm showing this case. Right? Now, in this para, you can see whatever I taught you just before, how to terminate the employee from the Teva Act. You can read it, but already I have taught it. Just read this para. Already you got the note. Anyway, you can read this. Now, zoom on the pen at the. It is clearly says the provision of the Teva. Okay. Now see the argument of the company. The company can argument. Make up the the company tried to catch this. Even the what the company's argument is, employee already signed the document, included this phrase. That means employee already given the letter of consent to terminate the employee during the probation period. තර්කයේ සාධාරණයි වගේ පේනවන්නේ. So here, company says the employee already given the acknowledgement for the letter of appointment. The letter of appointment says any time of the probation period, employer has the power to extend or terminate. That means indirectly the argument from the company, yeah, I'm not telling. That is the argument from the company. They say they can, as per the argument, right? They can extend or terminate the person based on that acknowledgement of the letter of appointment, including that phrase. Oh, yeah. Company के साधारण नहीं. දැන් ඔයගොල්ලෝ දුවනේ මේක legalize කියලා සමහර අය. ඒක තමයි company කියන්නේ. හරි. සමාගම සාධාරණයි නේද? වගේ පේනවා නේද? හරි. නිකන් සාධාරණයි වගේ නිකන් මේනවා වගේ නේද? So, yeah. No, you take some of the letter appointment, not some, most of the letter appointment, you can see without inquiry, without knowledge, you may terminate it during your probation. Ulage varante pati individual, after here the it is like that. Huh? You may say that is right? That is why it goes up to the court of appeal. Right? ඔයාගේ වතුර ලිපිය නැත්තම් හොඳයි ඉතින්. ඒව නැත්තම් හොඳයි. ඔයගොල්ලෝ ඔයාගේ කම්පැනි එකම දෙන්න නැත්තම් ඒත් හොඳයි. But most of the places we can see it. Right? Anyway, that's the argument of the company. That of appointment, there's a subheading. All probation. And that subheading says this power, authority to terminate. Right? You will be on probation for 6 months, which may be extended discretion of the management. During this period, you are going to be terminated by management without notice. අන්න එහෙම එකක් තියෙනවලු. ලු මන්නේ කියන්නේ ලු. ඒ නිසා ඒගොල්ලන්ට එහෙම අයින් කරන්න පුළුවන් ලු කියලා ඒගොල්ලෝ කියනවා ලු. Right? මේකත් කියව ගන්නකෝ. බලන්න කම්පැනි එක දේවායකරත් මේක සම්බන්ධ කරව විදිය. Right? Placing the signature මේක කියව ගන්නකෝ තරහක. Not the main argument. It's an argument from the company, not the final judgment. It's the argument from the company. Placing the signature for the letter of appointment, that means acknowledging the letter of appointment. It's a
portion that.
It's the provision for the employer to terminate the employee anytime that the clause is there. That means the clause is accepted by the employer. Therefore, the argument for the company is no need to get another letter, right? It's already consented. Now, you will learn the Industrial Dispute Act from this course, but as for the information, note down, Act number 43, 1950, Industrial Dispute Act, Act number 43, 1950, Industrial Dispute Act, Act number 43, 1950, not relevant to today's session, but I'm just for the information. Section 31B, Section 31B, 4 and 6. According to that labor tribunal has the power to give the order without considering the letter of appointment. So, ඔයගොල්ලන්ගේ wordings වලින් ලියාගන්න මම කිය මගේ wordings වලින් section එකේ enough wording. So, meaning is that labor tribunal has the power to give the order. In other wordings, labor tribunal can take the decision without considering letter of appointment. Okay, section එකේ ඔහොම නේ වෙන විදිහට තියෙන්නේ මම meaning the කිව්වේ. Act number 43, 1950, Section 31, B, 4 and 6. දැන් කොහොම කිව්වට පස්සේ ඔයගොල්ලෝ ගෙවල් වල ගිහිල්ලා ඔය ඇක්ට් එක අරගෙන ඔය සෙක්ෂන් එක විතරක් කියවන්න. අමාරු නෑ. right? ඒකට මේ සම්පූර්ණ මේ හොඳ full knowledge එකක් වෙන්න. නිකන් presentation slide එකකට සීමා නොවි. right? That is the argument from the company. Placing the signature can be considered prior written consent. මේ කොහෙද තියෙන්නේ? මේ වචන තුන කොහෙද තියෙන්නේ? දැන් කියන්න බලන්න. මේවා එකේ 2 1 කියන්න ඕන දැන්. ඒවා කියලත් මදි. Act number 45, 1971, ඒවා section 21A වල මෙන්න මේ වචන තුන තියෙනවා. Prior written consent. Now the company argument is by placing the signature for the letter of appointment, it's complete. Right? Now we'll see what happened. Now, what is the decision of the Labour Commissioner? To confirm this employee? No. I මතක නැද්ද පළවෙනි පැරා එකේ? Because he is terminated, order by the Labour Commission General to pay back wages, not to permanent. Not to the permanent is a different story. Based on the performance and evaluation, the employer can take a decision. But termination, another story. This is the Labour Commission General order to pay back wages, right?
So that means we can. We don't want to provide the member after.
No. How can you say like that?
No. Indirectly. Probation period is over.
When the probation period is over, if now really who is the probationer? The AY clearly says uh, he is running with the period of 180 days. Or another judgment also says who is the probationer? It is the time for testing both parties. Who are both parties? Employer is testing whether he is suitable person for my organization. Employee is testing whether this is a good place for my career. But it is the duty of the employer to aware the employee about the results of the test. පරීක්ෂා කරයි කියලා employer හීන දැකලා හරියන්නේ නැහැ. In writing, employee inform කරලා තියෙනවා I have tested you. කිසි වරදක් නැහැ මේ ටික හොඳයි මේ ටික නරකයි කිව්වට වරදක් නැහැ. මම කියන්නේ හොඳයි කියන එක කන්ට කරලා කියන්න. නරකයි because you are doing HR. The important thing is, if you got the code, everything depends on the evidence. Now however again then කියවන්නේ මෙතනද? මෙතන respondent කියන්නේ employee ah. Petitioner කියන්නේ company. Company is the petitioner, employee is the respondent. And also labor commissioner also respondent. Labor commissioner and the employee's argument is, according to Teva, there are two legal provisions to get the consent of the employee or else get the approval of the labor commissioner. It is the procedure. It is the it is the legalized procedure to terminate the employee. Right? Now the court says the primary question that needs to be resolved, whether acceptance of letter of appointment placing the signature can be considered as a prior written consent. Now, the question in front of the court is this. Can you do that? We'll see how it sorted out, right? Now, importance of the case law. Even the courts delivering the judgment, they refer earlier judgment. Sometimes the same court or another different court should be senior courts, right? Now they consider another writ case delivered by the earlier. Another judgment delivered by the earlier, right? That is Lanka Canaries versus Labor Commissioner. Again, it's a writ, right? And in this type of situation, you can note down the one party of name of the one party and the case number, that's all. And the decided date. That's totally enough. You can write down Lanka Canaries case, writ number 385/2021, decided on 2022. Again, one of the latest judgment. what the earlier judgment says, employee decide to terminate the services or even extend the probation, employer should follow a procedure according to the law. What is the law? Seva. Right? And the principles of natural justice. Right? Accordingly followed the process before extending the period of probation and terminating services of third responder. And the court clearly says, if you want to extend from this judgment, not this judgment, these earlier ones clearly says, if any employer wants to extend or terminate the employee during the probation, either following a rule of law or go through with the principles of natural justice. That means they can go with seva, or if there's a disciplinary matter, seva says it is silent, then you can go the disciplinary procedure. That's the situation from the Lanka campus case. And maybe මතක තියාගන්න හොඳට මේ නැතුව මේක තියෙන්නේ ඔක්කොම මතක තියාගන්න ඕනේ. Lanka Cambridge Street case 2022. It says, according to the rule of law or following a rule of natural justice, employer can take a decision. According to the law means seva, or if there is a disciplinary matter, following a rule of natural justice. එහෙම කරා නම් වරදක් නැහැ කියලා තමයි ලංකා කැම්පස් කේස් එකේ කියලා. Now see what is the importance of the case law. Even the same court, before delivering a judgment, they refer the that is the importance of the case law. ඉතින් මෙච්චර කියා දීලා මොඩියුල් එකේ එක්සෑම් එකේ උත්තරය ලියනකොට රචනා නම් ලියන්න එපා. ඒ අනුව සලකාන බලන කල මේ අනුව සොයන බලන කල කෙසේ වෙතත් එසේ වෙතත් මෙසේ වෙතත් මෙසේ විය. අවසානයේ මුකුත් නැහැ. පිටු හයක් හතක් තියෙනවා. ඔක්කොම දෙන්නේ කෙසේ වෙතත් මෙසේ වෙතත් එසේ වෙතත් ඒ අනුව සලකා බලන ඇත්ත වශයෙන්ම කියන කාල ඇත්ත වශයෙන් බොරු කියලා දෙන්නේ මොකද මුකුත් නැහැ. right? ඒක හොඳයි සිංහල සාහිත්‍ය මොනවද? තවදී මොනවද? බෞද්ධ ශිෂ්ටාචාරය වගේ දේවල් නම් හොඳයි එකල රජතුමෙක් වැඩ වසන තේක ඒ රජතුමා මෙලෙස කීසේක this is law. No need 1,000 pages. If you can mention the point, case number, act number, section, even 2 lines is enough. Even 2 lines is enough, but should be a act number, section, and relevant case law. ඒකයි මෙච්චර කියන්නේ. Hey, why we are trying so much when to develop your career life? When there is a board meeting in your organization, what I know, nice again, not take what a parliament. Right? When you are in the courts, then you are giving evidence on behalf of the company. So I mean, what I nice again, not take what it to say like that. Right? That act number අවුරුද්ද section එක මේකෙදි මෙන්න මේ නඩුවේ මෙහෙම කියලා තියෙනවා කියලා කියන්න පුළුවන් නම් you are the best people with the labor code. So the court mentioned the para of the Lanka Canaries case. Please read it. There is no law in our country to determine the length of the probation period. Right? However, it should be governed by principles of equality. And period for the employer objectively access whether workman would be suitable to carry out the duties and responsibilities. The probation is a period during the someone is judging, right? Your character and ability. It's very clear. That is from Cambridge case. It's very clearly says the probation is the period which someone is judging your character and ability while you work. Then it's up to the employee. What's the employee's duty during this period? To show the employer that I am having a good ability and character to right? That is the duty of the employee. සාමාන්‍යම උගන්වද්දී lunch period, tea time අරම වගේ නැහැ. ඒ වුණාට බඩගිනි වුණාම කන්න ඕන. දැම්ම කන්න බඩගිනි තව ටිකක් ඉන්න පුළුවන් ඔකත් අත්තේ. ඈ? ඉතින් ඒකටත් කතා කරන්නේ නැහැ. ඈ? පුළුවන්. පුළුවන්. very good. Now, from this para of this judgment, clearly having understanding what is the probation period and what activities should be done in the probation period. Right? What are the duties of the probation period from the employee? දැන් මේකේ තියෙන ඔක්කොම ලියා ගැනීම නෙවෙයි මේකේ තියෙන main points ටික ගන්න note. Main points. මොනවද? මේ තියෙන main point එක.
I have one doubt. This is all about labor. So, labor you.
Labor
Human one word is any particular law and we apply any function.
Yes. Yes.
You can say that
You will learn it. In case of labor law, there is a global situations are all. Global level labor law. Fortunately, Sri Lankan training matters. I was one of the lecturers there. International Labor Organization. Don't worry, you will learn it during this course about the ILO and the convention and protocols and recommendation, which it's a global one. The global some sort of legislation, but the relevant countries should develop their own law based on that. The global forum forced to the member countries to implement. So, if you experience then knowledge how it is the global standard, and of course, of course. If you are not following, you are not implementing, they can do, of course, they can have action. Because we are if there's a member country, but if we are resigned from the membership, now recently, USA resigning from the some organization, if they are resigned, there's no land. If they resign, they are right. Now, that is what the Lanka Capri's case express about the duties of the employee. Now we'll see. Now we'll see what are the duties of the employer according to the case law. Right? මේ පැරාගත් කියව ගන්නකො. Now මේකේ අපි මොකක්ද ඉගෙන ගත්තේ මේ පැරා එකේ? Duty of the employee. Duty of the employee. හොඳට බලන්න ඒකේ තියෙන එක නේද කියලා. Duty of the employee. Right? දැන් මේ පැරා එකේ මොකක්ද බලන්න තියෙන්නේ? Duty of the දැන් තේරෙනවද කේස් වල වටිනකම? අර ඇක්ට් එකේ පොඩි කෑල්ලකින් තියෙන එක කොච්චර එලැබරේට් කරලා දීලා තියෙනවද උසාවියේ. Duty of the employer. මේ ඡන්දයට මේකේ ඡන්දය යනවා දැන් කවුද පත් වෙන්නේ? මං කියන්නේ ඔයගොල්ලෝ ඔක්කොම දිනුම් කියලා. හේතුව when I am asking question whether your answer is correct or wrong, please answer. Right? Answer එක වැරදුනයි කියන්නේ පරාද නෙමෙයි. ඔයගොල්ලෝ ඉගෙන ගන්න. Right? දැන් මේක අදාළයි යනවා. නම ඇතිනේ එකක් නෑ. What is the duty of the employer? Right? Employer's duty not only assess the employee. That means he should assess. Not only again, that is one of the duty. One of the duty of the employer. Duty. අපි සාමාන්‍ය duty කතා කරන්නේ employee ට විතරයිනේ. No, there's a duty for the employer also. Not only access mean, no, sorry, assess mean, that means he should assess. More than that, training, guidance, supervisory, support to the employee. Right? Then කියන්න බලන්න, what are the duties of the employer when he is having a probationer? Assess, training, guidance, supervisory support. ඔය ටික කරන්න ඕන. Right? More than anything, mandatory duty of the employer to complete the formal review of performance. Mandatory duty of the employer to do the complete evaluatory performance. එතකොට ජුනි 15 හීනෙන් දැකලා ලියුමක් ගහපු එක ගැන මොකෝ කියන්නේ? When you saw a dream in June 15 and wrote the letter to the employee saying probation is extended. Is it legalized? Right? අර ඔයගොල්ලෝ උදේ බලලා legalize කියපු කොලේ ගැන මොකෝ කියන්නේ? Right? ඒ clause එක legalized නෑ. එහෙම පුළුවන් නම් තමක් පියෙන්නේ නැති අර ඉස්තරම මොකද්ද කියන්නේ? වැඩවසන් යුමේ මොකද පියෙන්නේ නැති. සාධ්‍ය වෙනකොට මිනිස්සු කානුවට පහින්නවා වගේ. ඈ? යකාවක් ගලවන්නේ නේද? එහෙම පියෙන්නේ නැති. This is having an employee-employee relationship and there's a duty for the employer. What are the duties of the employer? Mandatory duty. Complete formal review of the performance. Right? Complete a formal review. Formal review කියන්නේ කනට කරලා කියන එක නෙවෙයි. Formal review. Right? There should be some indicating system, evaluating system, various things according to your organization. We can't have a basic, we can't have a, some sort of framework. It depends on the facts and the things in your organization. If there's a sales organization, sales target. If it's a production organization, production target. Or any other evaluation system. It is a mandatory duty of the employer. When the probationer is employing. We cannot කියව ගන්නකො.
Hello, sir.
Yes. Yes.
Can I get a soft copy of this case?
No. No, the thing is this. I am explaining the case. You can go to websites or any other place, you can get it. I have, you can see I have highlighted and put some marks. Therefore,
Oh,
I am unable to share it.
that's awesome.
Only thing is very easily get the references. You can see the references here, case number. From this case number, very easily you can get it. It's not a hard work.
Okay, sir. Oh, thank you.
Right. Now read this. What is the key principle to terminate the employee even during the probation or to extend the probation? Right? Key principle to employer must follow a fair procedure. What is the fair procedure? What is the fair procedure? Using the favor, that's following a rule of law, or the favor clearly says if there's a disciplinary matter, no need to follow the favor. You can go with your disciplinary process. But even the disciplinary process, you can't dream. Muhora. Muhora nevi. You can't dream. You have to follow a proper disciplinary procedure. How can you follow the proper disciplinary procedure? You will learn it during this course, but I am just informing. You must have a disciplinary guideline in your organization. First important thing, you must have a disciplinary guideline in your organization. The reason, there is no legislation to maintain the discipline in private sector. There is no legislation to maintain the discipline in private sector. Therefore, you must have your own disciplinary guideline. එහෙනම් වැඩේ හරිනේ. අපිට ඕන විදිහට හදනවා. අය එහෙම කරන්නත් බෑ. එහෙම කරන්නත් බෑ. Based on the several other labor law acts and the case law and some sort of circulars of the labor department, you have to consider and develop your disciplinary guideline for your organization. And if there's a disciplinary matter, you have to follow that guideline and follow a proper disciplinary procedure by using an outside disciplinary inquiry officer. After that, after following that proper procedure, if the employee found guilty, it's up to the employer to take any decision. Whether you want to terminate the employee, whether you want to transfer, punishment transfer, or demotion, whatever the disciplinary decision can be taken by the employer after the proper disciplinary procedure. right? Now it clearly says a key principle to terminate the employee's probation or extended probationary, actually, employee must follow a fair procedure according to law. Not only that, it further said, employee has the right to make the application to Labor Department if it is terminated even during the probation period. Okay, now we'll see what happened to this judgment. I mean, what is the final judgment of this case? Now, there are two arguments from the both parties, employer and employee's positions. Employer says letter of appointment is the acceptance of the termination in probation. The employee says no, the employer has to follow the proper procedure. Then the court considered the earlier judgments. From that judgment, it found there are some duties for the both employer and employee. Now we'll see final judgment of this case. Now, what happened from the Labor Department? The Labor Commission General order to company to pay the back wages, but not to permanent reinstating or permanent, because he's under probation. Probation means it's the testing period, right? Now see what happened from the court. Please read the final judgment of the Court of Appeal. What's the final judgment of the Court of Appeal? I do not intend to interfere the Commissioner General's labor awarding back wages. Right? The reason, employer has not followed the proper procedure according to the law while the employee is terminating even in the extended probation period. What is the proper procedure? Deva or discipline. But anyway, they have not ordered to terminate. Sorry, permanent. They accepted probation period is the testing period. What they have challenged, the company's position saying they can terminate the person anytime, it is challenged. That is why they pay compensation. Right? So, morning hours, today's topic is type of employment. So morning hours, I use the time to explain the permanent position, permanent types and the probationer. I explain with the case law and theory law because nowadays these probation matters are a lot of, you can see a lot of, most of the employer feels, why, any misunderstanding or anything you want to clarify regarding this? Application dismiss. Huh? Not to reinstate. Why? Why? He's under probation. He's board clearly accepted. He's under probation. It is the company decision to reinstate or follow the proper procedure. Now the thing is here. Company has not followed the proper procedure. That is why I asked to pay the compensation. Or Deva or because of that.
They follow the procedure, they don't.
No, it is not employee. They follow a proper procedure. That means Deva or discipline. It won't happen. Nothing. That's There's no proof. Now they acted like that. Now you see, right? Appointed this day. Probation up to now. During these 6 months, nothing. Huh? Company paid. Right? Then extended for 2 months. Reason? Nothing. Right? So during that extended probation, he was terminated. No inquiry, nothing. That means not followed the proper law or disciplinary procedure. Right? Say. Once the court has ordered, you have to follow the court order. If you are not satisfied, you have only one option. What is that? I explained tomorrow morning, today morning. Huh? Only one option. You can appeal it to Supreme Court. I don't know. During this time whether this case is appeal or not, I don't know, because the judgment given in last December. If it is appeal or not, I don't know. So this is the situation. Only one option for the company. They can appeal it to Supreme Court.
During disciplinary issue, you say that with a outside person. So selecting an outside person, what are the predictions or the criteria we need to look at?
For the disciplinary part,
Yes.
should be a totally independent person. You can't get the retired person in your company. No relationship with the company. Should be an independent
Only
person.
the experience and other things.
Of course, you have to consider the experience and other things. He is going to be an inquiry officer without knowledge and experience. How can he do that? Of course, you have to consider that.
Specific criteria are not mentioned. No?
Again, you can take it from the case law. Other common practice is now I went to do the using one particular company as an inquiring officer. Union made the objection. Make on the example. Union made the objection and say, you are paid by the company. Therefore, we can't expect there is argument for the company. My reply was okay. You can share my fee 50% from the employer and another 50%. Right? That is, that is, when you make objection, it should be a sound one. ඔයාගේ එකක් ගහම නිකන් ඉව පිට මැන ගත්තනේ. මේ වෙලෙම තාංගාරු මම යූනියන් එකෙන් 50% ගෙවන්නේ. කම්පැනි 50 ගත්තොත් හරිය 50%. එහෙමනේ ඔබ්ජෙක්ෂන් තියනවා තියාගන්න. ඒක අනපැලෙන්න දාන්න පුළුවන් නුඹලා. එහෙම දාන මිස එක අර වගේ නිකන් දාන එක වැඩක් නැහැ. කතා කරන්නේ ගුරුවරයෙක් විදියටනේ. කිසිදලෝ. Yeah, outside this furniture in the hammer lower. Then what is my duty? Then what is my duty? Please tell me. If you detail me, what is my duty? Protect you. That's okay. Okay. Not to current then to a probation means it's the period of the testing. That way, I make termination එක වැරදි කියන්නේ කියන්නේ. Termination එක වැරදි නිසා that way just give. Permanent කරනවායි කියන එක it's another story.
However, the order to reinstate the group content should not be considered as satisfactory.
Should not be considered.
In order to reinstate sir.
In order to reinstate compensation. However, the order to reinstate the third respondent should not be considered. Labor can give one a reinstate කරන්න කියලා.
Okay.
Is not considered. ඒක අනිත් කෙනෙක්ට එක කියවන්නකො. Basic approval to make him permanent in his service without leaving room for the petitioner. කියන company නේ. Follow a proper procedure to assess the service. කියන්නේ මෙයා assess කරන්න නැතුව permanent කරන්න කියලා කියන්නේ නැහැ. But however, I do not intend to interfere avoiding the benefits. මේකට interfere වෙනවා මේකට interfere වෙන්නේ නැහැ. මොකද interfere වෙන ඒ decision එක challenge කරනවා. Right? Okay. Anything you want to clarify? Those who are in online, anything you want to clarify or any question?
So far, no, sir.
Okay. Really up to now, I have tried to explain who is probationer and who is the permanent employee under the types of employment. Those are the two main types of the employment in nowadays. Also two important types of employment nowadays. But we have to learn other types, fixed term, seasonal, those things. We'll discuss after lunch. It is not only for probation, including permanent, probationer, fixed term. Was up to now I have discussed only permanent and probation. After that we will discuss another type of employment. Whatever the employment is applicable. There. I'm permanent employee. The life of the person is one. According to the Deva, permanent means he is automatically extended his post annually, and he is having the legitimate expectation to work until age of retirement. That is the perm. Automatically renewed his yeah, I will show you. Judgment එක reinstate කරන්න බැරි දැන් perm එක මුදු කියලා නැහැ. දැන් දැන්වත් මෙයා terminate කරන්නේ. Compensation එක compensation. ආයෙත් කරනවා. So this judgment. මේක කලින් කියන්නේ reinstate with that thing. මේක ඔය reinstate කියන්නේ ඔය. That's what. Following the rule of no. After accepted, that is the argument of the petition. They accepted the court not granting the compensation. Right? Any other question? මම අර ඇක්ට් එකේ තියෙන permanent එකක් පෙන්නන්න.
Swimming යන්න ඕනේ. ඔයනවාද? 7:10. 7:10. මෙතනට යන්න ඕනේ. 7:10 දැන්. එනවා 7:30 යන්න ඕනේ. එතන නැගිටින්න ඉතින් මට. 7:50 ආවොත් මම කිව්වනේ වල 7:50 නෑ හැරුවොත් ඇති කියලා. ආදි ලෑස්ති කරන්න ඕන.
People who are in online, if you have a question, you can on your mic, otherwise mute it. Now, regarding your question, right? It says who is employer and what is employment, right? So according to that, if it is a permanent position, there should be a legitimate expectation, right? That he can work until retirement age. That means under the employer-employee relationship. Okay, in morning hours, I have concluded who is the permanent person, who is the probationer with case law and theory law. Now, just putting the slide and explaining things very easy for me, but I have followed the difficult procedure, mix the theory law and case law to teaching that type of thing, little bit difficult, but you are fulfilled with the knowledge, theory and practical, right? Okay, we'll meet us after the lunch to discuss about the other types of employment. Those are temporary, fixed term, casual, something, all those things. Okay, let's stop for the lunch. Time ඔයගොල්ලන්ට කෑම ගන්න විනාඩි 5ක් 10ක් 15ක් 1:15 it's okay.
Sir, excuse me.
Yes.
So මේ ඇක්ට් එක අපිට ඩවුන්ලෝඩ් කරගන්න පුළුවන්ද?
පුළුවන් වෙබ් එකට යන ඩවුන්ලෝඩ් කරගන්න පුළුවන්. මේ
Ah.
ඇක්ට් එක ඕන දෙයක් මේ ලේබල් වලට අදාළ ඕන දෙයක් වෙබ් එකේ තියෙනවා.
ඇමන්මට එකත් එක තියෙනවානේ අප්ඩේට් වෙච්ච එකක්.
ඔක්කොම තියෙනවා.
මේ කේස් එක බැලුවා මේ කේස් එක තියෙනවා සර් මේකේ.
අනිවාර්යෙන් වෙබ් එකේ තියෙනවා. ඔය
Ah.
රෙෆරන්ස් වලින් ගන්න. Are you working or studying or?
Me, I am actually I am abroad. I am in the UK now. I am here studying in the university.
Sure. Which sort of degree are you studying in UK?
I'm doing my masters in law.
Masters in law.
Mm.
From where you get your basic degree in law?
From University of Wolverhampton. That is also UK degree.
You are not hoping to coming back to the country, or you are?
No, I came recently to the UK.
No, I mean, you are not hoping to work.
I'm hoping to do the solicitors here and hoping to come back.
Right. Okay, very good. You can go to the website and you can download it.
Yes. It's early in the morning now. It's 7 o'clock.
Now it's 7 o'clock.
Mm.
We are in 12.
Yes.
12.
Yeah, I logged in at about 3:30.
Morning.
Yeah, early morning.
Is it? I say it is too hard for you, no?
What to do?
No, don't worry. If there's anything, you can use my WhatsApp numbers. I have given it to all, no? My WhatsApp number I have already shared, no?
Yeah, you didn't introduce yourself also.
I didn't introduce. No, I have shared my slide to having a better understanding. Wait. I will.
Oh, we'll meet after lunch. We'll meet after lunch then.
Oh, don't worry. Wait for 1 second. Wait for 1 second. I will put my slides to understand who am I. I'm really happy about your comments because most of the time, in case of online, people are silent. I don't know whether even hearing my voice or not. But even from the outside the country, you are replying. I'm very happy about you. Now you can understand who am I.
Yes.
Right?
You are a lawyer, right? Okay.
Not only
very
lawyer.
nice to meet you. Yeah, good to know. Yeah.
Okay. Is it enough for me?
More than enough.
All right. Okay, we'll see after lunch.
Okay, sir. Okay, thank you. Hello, sir. Hello, sir.
Yes.
Started? No.
Just going to start it.
Okay, sir.
How is, you had your breakfast?
No, not yet.
We had our lunch.
It's okay. Fine.
From where?
Sir,
Sri Lanka?
go ahead, sir. Go ahead, sir.
I mean, what is your mother town in Sri Lanka?
Colombo.
Ah, when did you migrate?
In front of near the law college.
Ah,
Law college. There's a Devani Boga. There's a in front of High Court. In behind the the backside of the High Court.
that means from the from your birthday time.
Yeah.
The law.
Yeah. From Mirania Street. Devani Boga. First Boga is near the magistrate court.
Mm-hmm.
There's a big Bogava. There's a temple. There's
Right.
another Bogava in front of towards the other side, not the Mardana side, towards Halstoff side. A big bow tree near that.
That means from your birth you are touched with the law.
Yeah. I entered the law college also.
Uh-huh.
Then 2017 I entered law college.
Have you completed and got the oath in Sri
First,
Lanka?
not the I am in the final year. I couldn't finish the final examination, but I have to finish it.
Mm-hmm. Okay. අපේ physical ඔක්කොම ටික ආවනේ. හරි ඇවිල්ලා. Right.
So අද අපි බැලුවේ මොකද ඒරියා එකද බැලුවේ sir?
Types of employment.
Types of employment, no? The
With
Act is Minimum Retirement Age of Workers Act, no?
we have considered various acts, not only Minimum Retirement Age Act and Termination Employment Act, Industrial Dispute Act. In case of labor law, it's like we can't touch one act and get the things.
Yeah. We can't stick into one act, yeah.
Complex you think. Now, in case of one definition, you have to go through various acts. Even today, I have touched Industrial Dispute Act, Termination Act, Minimum Retirement Age Act. So various things. The topic is types of employment.
Yeah.
Now I have completed the main types of the employment, that is probation and permanent. Now I am going to start another important thing in case of employment, types of employment, that is fixed term employment.
Okay. So will you be sharing the slides, any notes or something?
No, I don't have slides. I don't have slides. Then what can I share? You prepare a slide and share for us.
Okay.
By
Yes,
learning
okay.
these things,
Yeah.
prepare a slide and share to us.
Yeah, we have to prepare a notes, no?
Of course,
Okay.
because we are learning law.
Yes,
right?
yes.
Now, as a law student, in addition to this, law has no boundary.
We have to find the law.
Of course, with the theory and case law.
Yes.
Your name,
That is
please?
how
Your name,
I am
please?
Tufail Ahmad.
Ahmad.
Yeah.
Okay, Ahmad, you can make your own note. And if you like, you can share for the benefit of all.
Okay, I'll try.
Okay, now Ahmad, we are trying to explain fixed term employment, right? Can you see the screen now?
Yes.
This is from the Act. I am going to explain the various areas of these things. That is fixed term employment, right? Now, in case of fixed term employment, by wordings you can understand something. What is that? Cut off.
The term is fixed.
Temporarily cut off this the first word fixed. Then term employment.
Term employment.
Once you open it, it's clear. Term is fixed.
Mm.
What is the difference between permanent and fixed term? If it is a permanent, there is a legitimate expectation for the employee. He can work until the retirement. But in case of fixed term, you can't have that type of expectation. Right? Term is fixed. But මට මතකයට ආවා මේ HR එකේ හොඳ වැඩක්. එකක් කියන්න නේද? හොඳ දෙයක් කිව්වම මොකෝ වෙන්නේ නේද? Now fixed term. මම මේ කියන ડોකියුමන්ට් එක උසාවි දාපු එකක් හොඳේ. Now okay, what do you mean fixed term? Term is fixed. That means it may be 2 days, 2 weeks, 2 months, 2 years, depend on the situation. Right? Now, there is a letter of, even for fixed term, letter of appointment should be given. Why? There is a contract of employment between employer and employee which covered by the labeler. You can't say it is fixed term, no need the letter of appointment. No, it is the labeler employment. Right? One type of the employment under labeler. Then there should be a employee-employee relationship. Under that situation, you have to issue a letter of appointment. Then what is the difference between permanent and this one? This term is fixed. That means, now from my example, not mine, one of yours example, right? Fixed term, now only 2 pages letter of appointment. This is first page, this is second page, right? Here you can see the letterhead, all everything of the company, the employees detail, name and address, everything is correct. You can see the topic here, fixed term employment for 2 years. And you can see here, starting date 2022. I forget the exact date. Anyway, the year is 2022. First page. Second page, MD has signed. Here you can see the fixed term contract ended up year 2020. I forget the date. Why are you laughing? Fixed term contract. Why are you laughing? Ahmad, can you see the screen? Can you see the whiteboard, Ahmad? Or Ahmad, Buddhist.
So,
Right?
can see, sir, can see.
You can see this area.
Yeah.
Whiteboard. You see the fixed term started in 2022, ended up 2020. What do you see?
Backdated.
Can you do it? Can it happen?
Can't be.
What happened here really? This is the procedure followed by some HR people, that is cut and paste, copy and paste, arrange the first page properly, but unfortunately, second page.
Typo error.
You can't say error, Ahmad. This is contract, this agreement. If there's any single failure of the agreement, I mean, any single error of the agreement, what happened to the total agreement?
Agreement is not valid. It's all.
What is, tell me as a law student, what is the legalized word?
uh,
Null and void.
null and void, yeah. Agreement itself is not valid.
Yeah. Even in a one word. ශූන්‍ය හා බලරහිත. ඔන්න HR කට්ටිය මතක තියාගන්න. ඔය copy and paste, cut and paste ඔයගොල්ලෝ කරනවා. ඔන්න සනීපේ. Now documents in the courts, you can't change it. Right? If you correct it before, deliver the person, that's of course. Now you can't. Right? Start in 2020, ended up 2022, ended up 20. පළවෙනි පිටුව හැදුවා, දෙවෙනි පිටුව හදන්න අමතක වුණා. හැබැයි MD තස්සම් කළා. ඇයි එහෙම උනේ? HR එකකින් ගෙනාවා. තස්සම් කරා. Right? Okay. Now, what do you mean fixed term? Mean written contract. Again, it's a written contract of employment. Right? Covered under labor law. It's a written contract of employment. It's a written contract of employment. What is the special thing? For a fixed time. That is the important thing. For a fixed time. Then, in that situation, you have to mention specified days, months, or years. සමහර මගෙන් අහනවා ෆික්ස් ටර්ම් නම් අවුරුදු දෙකයි කියලා. කොයිද එහෙම තියෙන්නේ? එහෙම එකක් නැහැ. Yes. ඒක තමයි මාත් දැන් කිව්වේ. කොයිද එහෙම තියෙන්නේ කියලා. ඒ කාලය තියෙනවා. කවුද තීරණය කරන්නේ? ආයෙත් ඕන විදිහට එම්ප්ලොයිස් කොයිද ලංකාවේ තමයි. කාලය තීරණය කරනවා දෙපැත්තම එකතු වෙලා. ඔයා මගෙන් අහනවා ආයේ කම්පැනි එකට කන්සල්ටන්ට් විදිහට එන්න පුළුවන්ද? අවුරුදු 5කට මම කියනවා බෑ. දෙකයි. දැන් ඔයාලට 5කට මම බරි ගන්න පුළුවන්. පුළුවන්. ඒක නැති එන කවුද දෙන්නේ එක? So, දෙගොල්ලා. දෙගොල්ලා මේ employer and employee. Good question. ඒකේ නේද කරන්නේ? මෙහෙමත් කරනවානේ. අවුරුදු දෙකකට ෆික්ස් ටර්ම් එක ගැහුවා. සතියක් හරි මාසයක් හරි දුන්න සර්විස් බ්‍රේක් එක ආයි ෆික්ස් ටර්ම්. කේස් ලෝ තියෙනවා දැන් ඔක්කොම ටික මට වෙන්න අමාරුයි. The case law clearly says if the fixed term continues, the purpose of the same for the same purpose, same person is going to be a purpose. Huh? Break කරන්න? ඉතින් කරන්නේ employer එක ටීචර් කියන එක උසාවියට හොඳට තේරෙනවා. ඒක කරන්නේ බ්‍රේක් එකක් වෙනවා කියලා තමයි කේස් වල තියෙනවා. එකක් වෙනනම් ඉතින් මට ඔක්කොම එක්ස්ප්ලেইন කරලා ටයිම් පරි. දැනට මතක තියාගන්න. බ්‍රේක් කරත් පර්මනන්ට් විදියට සැලකෙනවා. හේතුව හොඳටම නීතියට තේරෙනවා it's the cheating. හැබැයි මෙහෙම වුණා if something happen like that, say employee A and employee B See, employee A and employee B having a fixed term. Having a fixed term contract for 2 years, right? Employees A is say engineer. The fixed term contract for constructing a building, right? Then this project is over. Now, huh? Can we explain from the start? Right. He is an engineer. The A is the employee. B is the employer. Right? Now B wants to construct a building. He is the civil engineer. Right? During 2 years period, the project is over. That means already constructed. Right? Now project is over. Fixed term is also over. Right? Now there is another project. Not for this. Having a separate fixed term and also terms and conditions different. Right? Another project. Right? Then it's a new fixed term. But most of the time, what the employer is doing, same person, same designation, same some sort of project. Only thing is 1 week or 1 month service day. And make an usually, you know, make a person. Right? සමහර වෙලාවට අවුරුදු 20 25 30 40 fixed term contract. මේක දෙකද මම මේ ළඟදී කේස් එකක් ආවා අවුරුදු දෙක මට මතක නැහැ අවුරුදු ගාන 23 වගේ නේද ලොකු ඩියුරේෂන්. දැන් යාගේ එන්ටයර් කැරියර් එක එතන. යනවානේ. Right? Void to avoid beneficiaries never young, but if the things comes to the boss, the employer getting trouble. I got you in what never another. At what how to find it? You're not දැන් අසෝතනේ අංක 12 පාරිතෝෂික පරතේ තියෙනවා ඔය 15 අවුරුදු 5 කතන්දර. Gratuity වලට. දැන් එතනසේ පාරේ අංක 43 සාධනකාරවලුනේ 31 එක B වල තියෙනවා පහනටත් gratuity ගන්න ක්‍රම. 15 කතන්දරනේ අවුරුදු 5කට අඩු වුණත් gratuity ගන්න පුළුවන්. LT. අසෝතනේ 12 පාරිතෝෂික පරතෙන් gratuity දුන්න නැත්නම් ලේබර් ඩිපාර්ට්මන්ට් එක. හරි 50 43 එකෙන් 31 එක B වලින් පුළුවන් gratuity ගන්න LT ඉතින් ඒ construction building එකේ එනේවා අපිට වැඩි තියෙන්නේ it won't come to the law. නවනම් different picture. එහෙනම් ඉතින් කමෙන්ට් කියලා පිළිගන්න ඉවරයි. ඔයා ගැටිටි කියන්නේ අසෝතනේ අංක 12 ඉන්නේ. පාරිතෝෂික පරතෙන්නේ. පාරිතෝෂික වල රික්වයර්මන්ට් එක අවුරුදු 5ක් තියෙන්න ඕනේ ගැටිටි කියවල. ඒ කියන්නේ ඔයා පර්මනන්ට් කියලා පිළිගන්න ඉවරයි.
දැන් අයිනෙද්දි ගෙවනවා. අර ඒ ටර්ම් එක අපි යූස් කරන්නේ in case of අර සමහර වෙලාවට දැන් එකක හොඳට perform කරපු මාසෙ ඊළඟ ප්‍රොජෙක්ට් එකට ගියාම සමානට ඔය අනිත් පර්පස් එක තමයි ඉතින් අතට මේ අනිත් එකේ සමහර විට ඒකට ප්‍රොජෙක්ට් එකට කේබල් නැති වෙන්නේ
ඔයාට ඕන විදිහට මේක රිජිස්ටර් එක දෙලා කරලා මොකද this is not a marriage agreement. This is the label of agreement. ඒක උදේ පාන්දර මම marriage agreement එක ගත්තේ ඒකේ මේකේ තියෙන වෙනස පෙන්නන්න.
transaction industry දුක කේබල් යනවා
තමයි යන අවස්ථාව දැන් තියෙන්නේ. දැන් නෑ මේ නේද එකක් ආවා මේක තමයි වෙච්ච එක ලෝයා මොකද
හරි
Right. In case of fixed term contract, what is the importance? There should be a specified මං කිව්වනේ මේක දවස් දෙකද මාස දෙකද අවුරුදු දෙකද ඒක තීරණය කරන්නේ ඔයගොල්ලන්ගේ වචන වලින් නම් ඉතින් employer තමයි. නමුත් according to the law both parties. මේ තියෙන්නේ පැහැදිලිව? Between an employer and worker. And includes the consecutive fixed term contract entered into the same individual. ඔන්න හොඳ කැලලක් එනවා හොඳට study කරන්න. Includes the consecutive fixed term contract. Consecutive fixed term contract. Entered into the same individual, where such contract is specifically linked to the performance of the particular task or project. Especially linked to the performance. Particular task or project, and the employer retains service of such worker after the end of the such fixed term. Then what happened? Without entering a new employment for more 12 calendar months. Without entering into a new employment. That means, study කරන්න. That means earlier employment. Without new. For more than 12 calendar months, shall be deemed to have an extended for length time identical to the existing fixed term employment contract. Right? So that is the situation of fixed term. Not only that, there are several case law saying if the fixed term contract is extended continuously, it will be considered as permanent. දෙක තුනක් තමයි මම පස්සේ වල දෙන්න. Right. Now the most important thing, if it is a fixed term contract, he also enjoying yes. අනික මට ඉන්නම නෑ. මට ඕනෙවත් නෑ. ඒක එහුට බලන්න. මෙච්චර අමාරු නේද? ඉතින් කියන්නේ නැහැ. මේ එක්ක ඉස්සරහට එන්න. ඉස්සරහට ඉස්සෙන්නේ නැහැ. මේක ඩිලීට් කරන් දෙන්න. ඉතින් මෙතන දෙන්නනේ. දෙන්නනේ. ඕනනම් මෙතන දෙන්නත් පුළුවන්. ඔයාටත් එහෙමද? ඉතින් ලේඩීස් ප්‍රශ්නේ අනේ පස්සට යන්න. මේ චෑග්. ඔතන ගෙලින් වද ඉන්නේ. මෙතන නේ. මෙතන ඔයාලට කැමති ඕනතනකට. නැත්තම් බෙඩ්ෂීට් එකක් පෙරවන් ඉන්නවා. මට ඉතින් එන්නේ නැහැ මම හිතේ ඒක ඩෝර් නම මට වාඩිලා ගන්නන්න හුරුවක් නැහැ. ඉතින් මට ඇවිදිනකොට කොහොමද මාවරක් වෙනවා. මොකද අපි ජොබ් එකක් හිටගෙන ඉන්නේ. right. Fixed term එකේ most important point is first point මොකද්ද fixed term එකේ most important point එක term is fixed. Right? Then some HR people and the employers doing very funny thing. What is that? Right? Now take that example. Not worry. Right. If the fixed term started 2020 for 2 years, say January 1st, right? 2 years mean කවදද? 2021 December අපි 31st කියලා අපගමු. එතකොට දැන් මම ගියා fixed term වල පළවෙනි point එක ලියාගත්තනේ term is fixed. ඒක තමයි පළවෙනි point එක. right? එතකොට සමහර HR managers ලා කරනවා මහබේට ඔෆිස් එකේ ගොල වැඩි වුණාම කරන්න දෙයක් නැති ගමන් මොකක් හරි කිව්වක් ගහලා නැත්නම් HR එක ගතියන්නේ නැහැ නේද? මේ විතර වෙන්න ඇති. right? HR එකේ දුමක් ගහලා තමයි කියන්නේ නැහැ. අර වෙන්නේ නැහැ නේ. ගොඩක් තියෙනවා කම්පියුටර්ස් තියෙනවා. ඇයි නොගහන්නේ? right? What is the letter? Now already given the letter of appointment under fixed term. Right? It clearly says your appointment only for 2 years, starting for this date, ended up 31st December 2021. Clearly given. Say around December 15 or 20th, sending a letter to employee, you will be terminated on 31st of December 2021. Why you are issuing that type of letter? Only reason I can understand, there are enough papers in the company and no work for the HR. That is why issuing this type of letter. HR එකට වැඩකුත් නැතුව ඇති පොළක් තෝල් තරම් ඇති කම්පියුටර්ස් ඇති ඒ නිසා රිමෝට් ගන්න. Otherwise, why you are sending this type of letter? What is the main theme of this fixed term? First thing, term is fixed. Second thing, please write down, automatically terminated. ඒක ආයේ HR එකේ ලියුම් ගන්න ඕනේ. Is automatically terminated when end of the fixed term. That is fixed term. Right? Automatically terminated. I terminated කියලා ලියුම් ගන්න ඕනේ. Right? Now, the question is this. Okay. Now, from this example, he should be automatically terminated 31st of December 2021. Now, it is 2022. Now it's January. No extension. Not terminated. He is coming to work. Employer allow him to work. Now he worked for January. He is paid the salary for January. Salary paid. Right? Now what you can understand? That means employer needs the service of employee. Employee willing to, employee has the consent to give his service. In other words, employee-employee relationship continues. That is why he is paid salary. That is why he worked for a January. So that means both parties agree to, right? ඉතින් මෙහෙම මාස දෙක තුනක් හතරක් පහක් වැඩ කරලා ළඟට ඇවිල්ලා කියනවා එම්ප්ලොයි ආවිලා කියන සර් මේ 10 විතර දුන්නා ඇක්ෂන් එකක් ගන්න බැරි. මොන මගුලකට ඇක්ෂන් ගන්න? දැන් 10 විතරක් ඕන. අයි පඩි කියලා තියෙන්නේ. right? මම අහන පඩිය කෑෂ් වලින් අතර දුන්නා නෑ නෑ බැංකුවට ට්‍රාන්ස්ෆර් කරා. පේ ස්ලිප් එකක් තියෙනවා තියෙන්නේ. ඊටම මොකද මප්පින්නේ? පඩිය බැංකුවට ට්‍රාන්ස්ෆර් කරලා පේ ස්ලිප් එකක් තියෙනවා. තාම මොකද මප්පින්නේ? ඕනේ. Right? Now, I told you that importance of letter of appointment, yes, it is important. දැන් මම කියනවා ඕනේ නැහැ. right? Right? Already given an initial letter of appointment. It is with you. Now, even the fixed term is over. The same designation, same place, same person, working in the same job. And he is getting a salary. Duration over, but both parties, it can be considered as both parties agree. Right? Then අනික සීල් ලිපිය නැති වුණාට බැංකුවට සල්ලි ගිහිල්ලා තියෙනවා. ETF කැපිලා තියෙනවා. පේ ස්ලිප් එක කැපිලා. මොකක්ද? Right? එතකොට so the main 2 points, term is fixed and automatically terminated, right? Okay. Now, during the fixed term, එක ලියාගන්න points දෙක. Term is fixed, automatically terminated. End of the automatically terminated when? End of the fixed term. මැද නෙවෙයි. Automatically terminated end of the fixed term. Like point form එකේ ලියාගන්න long message වැඩක් නැහැ. වාර්තා තේරුම් ගන්න පුළුවන් වෙන්න point form එකේ ලියාගන්න. අපේ ඉන්න of course, it is okay. Then if the employee says, I don't want to continue this job, it's up to, in that situation, he want to do the resignation letter. ඒකත් මේ employees කරන වැඩ. Fixed term එකේ වල resignation එකකුත්. මොන මොකලකද? Right? යාට ඕන නම් මේකෙන් පස්සේ දෙසැම්බර් 31 වෙනි මාසේ වෙන ජොබ් එකකට යනවනේ ගෙදර ඉන්නානේ කොටින්ම කියනවා මේ රස්සාව නොකර ඉන්න. ආයි මොකද ලියන්න ඕනේ නැහැ. යන්න ඕනේ නැහැ. No obligation. Right? Right. Those are the main features of the fixed term contract. Now the question is, during the fixed term contract, not the end of the fixed term contract, during the first fixed term contract, if the employer wants to terminate the employee, what is the law relevant? Again, it is Termination Act, which we discussed in morning, 21A, 21B, and if the disciplinary matter, that act is silent, then disciplinary proceeding. During the fixed term contract period, if the employer wants to terminate the employee, same procedure as permanent category. ඕකත් සමහර employers හිතන් ඉන්නවා මෙයා contract නේ. මෙයා permanent නෙවෙයි. Permanent වගේ තමයි අවුරුදු දෙක. That's the thing. End of the 2 years, there is no employee-employee relationship. That's why I told you, during the fixed term period, not ended the fixed term, right? You can fight as an employee during the probation period. If it is ended, the reason, if it is ended means marriage is over. employee marriage is over. ඒක marriage එක නම් මොකද්ද කතා කරන්නේ? Right? Lazy වචනේ මතක තියාගන්න marriage කියලා. But this marriage between employer and employee, not the civil marriage. ඒකට marriage කියන වචනේ use කරන්න එපා. මම මතක තියාගන්න කිව්වේ. තමයි කියන්නේ ආමුදයි දේවිකාවයි නම්. Done. It will make it even in the, I told you, the fixed term contract, it's similar to the permanent card during that period. During the fixed term period. Right? So in that situation, even in the fixed term, if the employer wants to also check the person, yes, 6 months may be probation. Not only employer, even employee. He can decide whether I am using my 2 years of life to this place or not. ඊටි අවුරුද්දේ කාලයක් මෙතන දෙනවද නැද්ද? right? ප්‍රොවිඩන්ට් එක හිතන්න පුළුවන්. right? So in case of fixed term contract, during the fixed term, relevant law should be applicable. If the employer wants to terminate, another point that we are gonna, during the fixed term contract, terminate කරනවා කොහොමද? Here. You're working in HR? Both of you? What's the company? Mass audit. Kate? Okay. That's also engineering. Huh? So you are doing constructing in Iron Bay.
It was on the building plan. We do not like something happened to building, but just lining the building. I mean, like plumbing, electrical, fire, and that.
That means you are having a big crew Iron Bay. Oh, yeah, team bike.
Yes. So here they are about like 800 but now because even the education lot of employees have less than yeah. And around like 2015, like most of the construction now like position, so they are not like 5 million.
Because of this Indian prices and all those things. Anyway,
Kind of
controlling 800 also, huge challenge for the HR. Because not the similar 800.
yeah.
If the all 800 are similar, nothing. Various categories, various minds, various qualification, various demands. And anyway, you have to satisfy the boss also. Otherwise, your job is over. How does the charging of public charge? Same company. You are
Okay.
so second. What is your proof? Is the previous challenge. Huh? Right. Anyway, fixed term ගැන මොනවද අහන්නේ? ඔයගොල්ලන්ගේ කැරියර් එකේ ආපු issues තියෙනවා company names කියන්නේ නැතුව අහන්න.
Yeah, we work for the project. And because they do the mission,
One specific project.
so that particular mission is the line 2 years. So we have entered into the agency. Because that we have taken the once we have entered into the really couple of years. So we have entered into the agreement with the employee. Then suddenly due to the government giving on the real project has been suspended. Extension project that we have definitely suspended. Then at that time with the employer we have like it was mostly the professionals involved in the doing of the project. So we have this interview agreement for the presentation and we have stayed it and just mutual understanding it was finished. But we'll say like not the same mindset of employees. So in such case, so what happened? Like
Please, let
we
please.
have mentioned for the specific.
No. You can't say we have no excuses to say like that.
Hmm.
Because already you are of the already entered the employee-employee relationship. That means agreement, right? That situation you are from your initial agreement. So that is the failure of the most of the even mega companies. In cut and copy, make a paste and copy නේ. වෙන කොයි සමාජාලේ වෙබ් එකට ගිහිල්ලා agreement එකක් අරගෙන ඒක copy කරලා නම දාලා ගහලා දෙනවනේ fixed එක. මත් කරන අවස්ථා තියෙනවා. So the main important thing if it's the fixed term agreement or permanent agreement or whatever it is, you should clearly identify the terms and conditions, thinking various ways. The broad mind. If these things happen, what can we do? Like there should be a terms and conditions in this set of appointment, mentioning these things in a broad manner. Now, as example, if you say like that, company has the right to terminate your services if the service is not required for the company. Totally indeed. Right? Now, some companies saying like that. If the bank rate or whatever out of the things for the company, beyond control, things comes up. Your fixed term contract may be ended up suddenly, in leave. Right?
I have one regarding without your word, if the some kind of a social in the business industry, so in Diva it says that also reducing the manpower. Yeah, we can.
You can. But the way is given in the section 2(1)(b). Get your approval from the Labour Commission.
We have to write it and say, I mean,
Just because of writing letter, he won't give the approval. With the reasonable grounds which going to be beyond your control.
oh, it's my control.
That of course, you can get the approval from the Labour Commission, but this again, some sort of difficulty because once you receive your request to the Labour Commissioner, definitely he will produce it to the copy it to the employee and get the comments of the employee. If the employee says no, this is completely false, enough profit with the company, no appeal will be given. It's the discretion of the Labour Commission. But there are very simple things to do these things. Simple reason means when you are preparing a lot of point, right? So go through entire SEVA, Industrial Dispute Act, Shop and Office Act, and Wages Board. හතර එකට අරගෙන කේස් ලෝ ටිකක් කියව ගත්තා නම් හොඳට සමහරවල් වැඩක් නෙවෙයි වචන දෙක තුනක් කරකවල ගහන එකයි තියෙන්නේ ඒකම මෙන්ෂන් කරලා ඉන්න. හරි අර ඔක්කොම ටික එකතු කරලා ගහන්න. right පිට වෙලාව තමයි කරකවන්න ගියාම යන්නේ නේ. Now probation I am not going to talk in again. This probationer. Then there is another employer there. Now, how many types of employment up to now we have discussed? Permanent, probation, and fixed term. Right? Thank you. Seasonal employment. What I කියව ගන්න මගෙන එක. ඔය ටියුට් එකේ තියෙනවා කියවන්න එපා. ඒක තියෙනවා. ටියුට් එකේ තියෙන ගෙදර ඉන්න. You need to go out for a 5 minutes. You can. You can. මොකද issue එක?
The term contract is the time of engagement with the period
Shall be
term of exit.
named indefinite term of contract if the time of engaged 12-month period shall not exceed 6 months. That is seasonal employment. I will explain it. දෙන්නෙක් නේද කියලා ඊට කියන්නේ. දැන් දාගන්න short note එක. short note කියන්නේ මොකද්ද? මේක චූටි අකුරෙන් ලියා ගන්න එකනේ. ඊට පස්සේ ඇස්ලි දාගන්න. නෑ. Short note mean in very short form to understand for your own, not for others. මේ ආවේ නෑ සාමාන්‍ය. මේ ආවේ. ඒ ඔයාගේ බෑග් එකද? නෑ තවි. ඈ අයියෝ මම මෙයා එනකම් බලන් ඉන්න ඕනේ. right. Now we are talking about the seasonal employment of country. Again, it's a label of contract. What is the specific thing from wordings you can understand? It's a seasonal one. Especially tourist hotel and things, huh? Oh, sometimes. The things they are functioning only one season for the year. Huh? So, in that situation, what the employer can do, if the employee only for that season, it should be given in writing. That of according to. There is some maximum period. Not exceed 6 months. Right? And make it in a points right? In case of that, it's only for season. Only for a season. Only for a season. Specified seasonal work. Specified seasonal work. Then, third point, time to be specified. Right? And such contract in days or month, time period days, month, specify and entered under actual or other basic which shall not be indefinite term contract. Definite එකක් and if the time of engagement in each 12 months period shall not exceed 6 months. That means there is a limit, not like fixed term contract. Fixed term නම් මාස 6ක් වෙන්න පුළුවන්, දවස් 6ක් වෙන්න පුළුවන්, සති 6ක් වෙන්න පුළුවන්, අවුරුදු 6ක් වෙන්න පුළුවන්. But here clearly says not exceed 6 months. Huh? Oh. Huh? Labor department online commitment Don't worry, from this course, EPF, you will learn with the theory and case law, most probably with me. EPF අනුව බලමු තත්ත්වෙ මට විනාඩි 5ක් විතර යට ගමු මොකද it's an important question නේ මට ඒ ගෙවන තැන ඇඩ්‍රස් එක විතරයි ඕන. මොන බලා ගන්න EPF එකේ තත්ත්වය මේක අද පාඩමට අදාළ නැහැ. ඒ වගේම කලබල වෙන්න එපා. මේ පාඩම ඔයගොල්ලෝ you will learn this act during this course in detail, right? But anyway, every person employed in any covered employment, right? Other than holding office of director, partner, any specific provident fund scheme, outside Ceylon, except that all are entitled for the EPF, right? Now, interpretation එක මම පෙන්නන්න. එහෙනම් මම කියවන විනාඩි දෙකක් දෙන්න. right මම තේමන ගමන් ඔයගොල්ලෝ බලන් ඉන්න ගමන් එකක් ප්‍රශ්නෙට උත්තරේ දෙන්නම්. එහෙම කරන්න බෑ. EPF ඇක්ට් එකට අනුව එහෙම allowance of ගෙවන්න නම් එකම එක ක්‍රමවේදයයි තියෙන්නේ. EPF නොගෙව allowance of ගෙවන්න එකම එක ක්‍රමයයි තියෙන්නේ. ඔයා ඡන්දෙ වල පාර්ලිමේන්තුවේ යනවා. ඒක පාර්ලිමේන්තුවේ 2/3 majority එකකින් EPF ඇක්ට් එක සංශෝධනය කරන්න ඕනේ. ඒ ආරෙන්න ක්‍රමයේ අන්‍යාය පුතා දැනට එක දවසක් සේවයේ දෙව්වත් EPF ගෙවන්න ඕනේ. EPF ගෙවන්න ඕන. ඒරුවේ නැත්තම් වෙන සමීපේ EPF ඇක්ට් එකේ සර්චාර්ජ් වලින් බලා ගන්න. It's a criminal offense. Case filed by the magistrate court. If you are guilty, definitely employer will get the paying benefits. What are that? At least 14 days free accommodation with food and transport and clothes also. You know it? සේවා යෝජක වර්ධකරු වුණොත් අදුම දින 14ක රජයේ ගානේ මොබිලේ නවාතන් පාසුකම් ප්‍රවාහන පාසුකම් ආහාර පාන සමග මෙනුත් පැලදුණු යන්නේ. right baby. Depan office act එකේ අපි ඉගෙන ගන්නවා. කොහොම සමහරවිට ගන්නවා වැඩි දින පැය ප්‍රශ්නයක් වෙනවා. ඔය ටික ඔයගොල්ලෝ ඉගෙන ගන්න බයද? මේ ඩිප්ලෝමා එකේ ඔක්කොම මොඩියුල් 9ක් 8ක් නේ. තාත්තේ 9ක් නේ. දැන් කොහොමද? ඒක මොඩියුල් 8ක් ද? මේ ඔය ඔක්කොම ටිකද? උන්ට ඉගෙන ගන්න බයද නේ. ඊමේල් එකෙන් මම නිකන් හරි අසාධාරණ නෑ ඔයගොල්ලෝ බලකින්න මම ජර්නීසියෙන් කරන් බොන අපිට මෙච්චර මහන්සි වෙනවා කාලයක් ඉන්නවා ඉතින් මම හිතන්නේ ජී ස්ටෝක් ගැන දීපයිදී අප්ඩේට් හරි සාමාන්‍යයෙන් අවුරුද්දකට කියලා සමාජගත පරිදා විස්තරය ගන්න කරනවා ඒ ස්ටෝක් අපේ ලොකම කාර්යවල තියෙනවා ඉතින් තෝටේ කාර්යවලදී නමුත් ඒක දෙන්න දිවිලා කරන්නේ කිසිම දෙයක් නෙට්වර්ක් එක ගන්න කිව්වා. සංඥා යන්නේ මම.
අත වන්දනා කතාවම කියන පොත් සම්බන්ධ කියන දුවකට ඔක්කොම ඉන්නවා දෙයක්. මම හිතුවා උඹේ වයර් එකේ යටවැරේ අල්ලලා කොහොමද ඒක ටෝස් මාවින්ක කාසු වෙනවා. ඕවගේම දෙයක්ම ඔය වෙලාවට තියෙනවා. අලුමයික මොකද නියම ඉතිරියට ගන්න තියෙනවා. ඒ දෙකේ ගාසින් වාන්දු. ඒ මානසිකව ඉතින් මොකක්ද ඇති ලෝනිය සප්ලයි කරන මොකක්ද උතන ඇති. ඒක ඊට පස්සේ එනයි අමුද එක්කලා හදියක් ඉතින් ඉතල ප්‍රොටෝකෝල් මෙෂින් වලට අරගෙන තියෙනවා මේ ස්පෙක්ට්‍රල් මෙෂින් වලට අපිට යම් ඩ්‍රාම සම්පලය ඒ පොඩි පොඩි අපිට ඒක නෝද අනගම පොලේ ගිහුවොත් ඒ තේින්න අපිට ස්පෙක්ට්‍රල් ඩ්‍රාම ඒ පොඩි සිස්ටම් එක වෙනවා ඒ ඉන්බලියම් සිස්ටම් එක අල්ලාහ් ඉන්නේ මගුලේ නිදුලිය නැතයි තෝලේ ඊවි නිවුස් වල බස්සලා යන්නේ ඒක ඉදි කවුන්ට් ගන්න මොකද මේ විස්තර එක පැත්තක් ඕකේ මොකක්ද කියන්නේ මොකක්ද කියන්නේ ඒක කොහොමද මොනවාද යනවා ආරේ පස්සේ කියනවා කියන්න මම හරියට කියන්නේ ඒක රෙලාටි කියන්නේ
මේක නම් බලන්න මොකද දැන් අපි ආයේ ගියේ ආයේ පෝස්ට් කරන නැත්නම් ආරුණාට මොකයි ඉතින් අපි අර සාමාන්‍ය යන්නේ ඉතින් ගියේ යන්න බෑ ඒක අනිත් කටියට යන විදිහට කරනවා
පීරියඩ් මැනේජ්මන්ට් එකේ කියලා ගොඩක් ඉන්න අරගෙන ඒක සබ්ජෙක්ට් ඉන්න කරලා මම ඒක බලලා අපි හරියට තමයි ඒ වගේ ඒවා ඉතින් මේ කතා කරන්නේ road based ඉතින් ස්පෙસિෆයි කරනවා මේ වගේ ගැන කතා කරන්න දිවිය. මොකද ටැක්ස් වෙනස් වෙනවනේ. නාවදී බියෝඩ් ආර්දේවා තුන බියෝඩ් කන්ට්‍රෝල් කියන්නේ. ඒවා වහලා දාන්නව නැතුව. ඒක දාන්න නැත්නම් ඉංග්‍රීසි. එන්නේ වහලා දාන්න ඕනේ නැතුව. road mind. ඒසර කාල් කියන මේ දැන් එක තමයි. කොන්ඩිෂන් එක කියන මම ඒක කරනවා. මම ඩිසිප්ලින් ඉන්ට්‍රොඩියුස් LP මැටර් කොහොමද කියන්නේ උනා කියන්නේ ඒක ඉතින් ඒක දාගෙන ඊට දැන් මම සබ්ස්ටිට් එක උත්සාහයක් ඒ වෙලාවට ලෙක්චර්ස් කියලා නෙමෙයි පොලිස් ගමින්ගහනවා වෙන්නවා කරගන්න අපි පොඩි විදිහට කියන්නේ ඒක තමයි අපි කියන්නේ මේක කරන එකකින් තමයි
ඉතින් කරා
ප්‍රතිපාද වෙන්නේ ඒක දුන්නේ නැහැ
එන්නේ මේක ඉතින් බෑනේ අපිට බාගන්නේ ඉස්සරහ කෙනෙක් ඔව් වැඩි තියෙන්නේ ආවස් නැහැ දැන් ඒක දැන් ඉස්සරහලා තියෙන්නේ මම ප්‍රතිපාද ගත්තොත් ඒගොල්ලෝ මේකම ගන්නවනේ ඔව් මම ගන්නවා ඒ පාඩම මේකමනේ ඔන්න ඔය කියන එක නේද
ඒක තමයි කොම්පියුටර් එකෙන් ඉස්සරහට තියෙන්නේ
ඒලා කියන්නේ මම දැන් අවුරුදු 15ක් තිස්සේ හිතාදිකපේ සත්ත පලාතේ ඉන්නේ සුදුද කල් දෙක ගන්න එන්ටි කියොත් කියන්නේ ඊපේ පීඩිඑෆ් කේස් එකකට විතර තමයි ගැටි මේ වගේ යන්නේ සිංහල ලෝ ටච් කරලාම LP අපි හයිපා කරමයි කරන්නේ දැන් ඒ නිසා මේ කියලා ඒ පිටින්දේ මේ කියන්නේ පිටේක ආව දැන් ඕනක් කියලා අවුරුද්දයි අන්තිම පිටින් යනවා මම කියලා
මේ ඕවරෝල් වලින් කියන තමයි වගේ දෙයක් හදන්න පුළුවන්. ඕවරෝල් එක තියෙන
එතන කම්පැනි වලින් කරන කාන්තාර
ඒක දෙන්නේ හරි වෙනවා.
නෑ යන් බෑන්ඩ් හරියට වෙලාවට සෙට් වුණොත් ඒ මොකද කේස් එකකින් අපේ මොකද ලොකු ක්වෙස්චන් එකක් අකාඩමි එකක් සෙට් වුණොත් ඒ ඉවරයි දාන්න
උත්තර ලෝය කෙනෙකුට සෙට් වෙනවා කියන්නේ
යන්න බෑ ලාස්ට් යන්න
දැන් මේ මාතර මනම් විශේෂයෙන් තරම් දුන්නා reinstate with the activity. මොන්ට කාලෙම
Reinstate with back pages. Another මනුස්සය WhatsApp කරලා ඒවල කරන මට ජජ්මන්ට් එක. يعني ජජ්මන්ට් එකේ hard copy එක. Reinstate කරන with back pages. දැන් කම්පැනි එකට උදව් කරලා පායි. ඒකේ පාස් කියනවා. මාතරින් මේ ගැටියෙන් යනවා. එන්න කම්පැනි ඉතින් වාරික තියලා. හරි. මම කොහොම හරි ඔප්පු කරා මේ වාරික ඉන්ජස්ටිස් ජස්ටිස් වාරික පාචල් කරලා යනවා. නෑ වාරික මේ මගාව විතර ඉතින් ටැක්සියක් වෙන්න දෙකියෝ ඉතින් ගිහිල්ලා කියනවා ඉතින් කියලා කම්පැනි කියන්නේ මට කොරාද කියලා හරියට definitely company එකක් විතරයි. මොකද එයා worry about their ඒකේ උනේ මෙහෙමයි. කම්පැනි එක disciplinary procedure එක කරලා තියෙනවා. හරිද? outside inquiry officer කෙනෙකුත් අරන් තියෙනවා. හරිද? ඒ වුණාට ඉන්ක්වයරි එකේ මෙයාට හරස් ප්‍රශ්න අහන්න දීලා. මම ඒකෙන් ගත්තේ මේක rule of violation of rule of natural justice unfair inquiry. Reinstate with back wages with compensation. ඒවා මොකද වෙන්නේ? ප්‍රශ්න අහනවා කිසි දෙයකට උත්තර දෙන්නේ නැහැ මොකුත් අහන්නෙත් නැහැ මම මෙහෙම දෙයක් කරා මම රෑ 10ට ලෙක්චර් එක ඉවරයි කියලා කිව්වා thank you good night කියලා ගොඩක් අය log out වුණා මම log out නොවි කැම් එකයි මයික් එකයි මියුට් කරලා මං ගිහලා වොෂ් එකක් දාලා ටීවී නිවුස් බලලා කාලා සාමාන්‍ය රෑ 11ට විතර කියලා බලුවා අනේ දෙයියනේ මේගොල්ලෝ තාමත් login මම ඊළඟ දවසේ ඒකේ ස්ක්‍රීන්ෂොට් එකක් අරන් දාලා පෙන්නුවා කිව්වා මේ අය ගැන මම හරි ආසයි මොකද මම ලෙක්චර් එකෙන් ඉවරුනාට පස්සේ තව මොනවා හරි උගන්වයිද කියලා ආසාවෙන් රාය 11ම ආරණකම් ඉඳලා තියෙනවා මේ තමයි උනන්දුම පිරිසගේ ඒ ඇත්තනේ අනිත් අය ලොග් අවුට් වුණා මේගොල්ලෝ තමයි 11ම ආරණකම් බලන් ඉන්නේ තව මොනවා හරි දෙයක් උගන්වයිද කියලානේ ඒ තරම් ඒ තරම් උනන්දුවක් ඉතින් එහෙම කරන එක තේරුම් ගන්න නැහැ මොකද මුදල් ගෙවලා කාලය වැය කරලා
ලේබල් එක නැවැත්විත් එහෙම මේ ඔන්ලයින් ඉතින් ඒව නම් ටිකක් හරි මේක වගේ ඊටමත කට්ටිය
අද වෙන්න හේතුව ඒගොල්ලන්ට බල මේක අල්ලගන්න බෑ ඒ නිසා තමන්ගේ
අපි ලයින් එකේ ඉන්නවා.
ඔයගොල්ලන්ට එක තමයි කියන්නේ මේ අහමද
ඔව්.
ඒ ඔයාලා ඉතින් UK ඉඳන් එන්න බෑනේ ඔයාලා ඉතින් ඔන්ලයින් තමයි
ඔව්.
if you can come to the Sri Lanka every Sunday you are most welcome
No, I am also following the lecture.
right no now Ahmad there is Supriyanto
Yes, sir.
there is Mr. Priyanto who is the director and training in charge here and asking the your choices whether you are coming whether you are happy to be in online or physical.
The physical is very, very effective.
You like physical, no?
Physical is very effective. So we interact in person, and we will have the lecture experience, and we can ask, we can meet lecturer directly. Then there's a difference between the online and the physical thing. There's a vast difference. Online, of course, for our people like us, is online is the no option. Online is the one and only option to follow the course. Otherwise, hello.
නෑ මෙහෙම කරන්න.
පහයි හයයි සතු පාර්ටිෂන් එක හතයි.
right මෙහෙම කරන්න. ඔයගොල්ලෝ මේ සර්ට හරි අර කෝඩිනේටර් කරන මිස් ඉන්න ක්‍රිස්ටිනා මිස් කතා කරලා කියලා ඒකට ආයතනයෙන් තීරණයක් දෙන්න.
ඇයි නෑ වැඩි පිළිස් එනවා නම් නේද නැත්නම් කම්බලින් එක
ඒක දැන් ක්ලාස් එක ඉක්මනට ඔන්ලයින් එකේ කරන්න පුළුවන් මම පහළ ඉඳන් මෙන්න මට ඔන්ලයින් එක
එහෙනම් මාව එකගෙන ඉන්න බැරි. මොකද මාත් ගාල්ද? මෙයා ආයෙන වාහනේ මටත් එන්න පුළුවන්. දැන් ඔයාට ගාලා අමාරුනම් මටත් අමාරුයි. මම පයින්නේ. ගාල්ලේ කොහෙද පුතා? කොයි ඉස්කෝලේ සංගවිත්තද?
ඒකට ඉන්නේ ගාල්ලේ මේ ෆෝන් එකේ වත්තරින්
මේ කොග්ගල. මොකද කරන්නේ ඉස්සෙල්ලා?
ක්‍රිටිකල් බීට්
ඔන්ලයින්
මොකද හරි ඇක්ට් එක? ඕන පැත්තකට ගමු. හොඳයි ගමේ එක්කෙනෙක් අතර ගත්තා නේ. තව කවුද ගාල්ල මාතර පැත්තේ ඉන්නේ? ආයිද? මාතර කොහෙද? මම දිවා වැඩ කරන නිසා හරි ගානිනවා. එයාත් නේ වැඩ කරන්නේ. ආසිරි මෙතන චීන කොට. ඔයාලා නෙමෙයි ෆිසිකල් එකේ මෙතන ඇවිල්ලා දෙන්නේ 3 දෙනෙක් ඉන්නකොට මම කල්පනා කරනවා එච්චර මම මහන්සියදායි මොකටද කියලා. ඒක මට මම විතරක් නේ මම අද නිසා මම ගැන කතා කරන්නේ. අනිත් ලෙක්චරර්ස්වත් මේක නිද තියෙනවා. ඒක බෝරින් වෙනවා ලෙක්චර් එකනේ. ඉතින් ඔයගොල්ලෝ කතා කරලා එහෙනම් මේ සර්ට කියන්න සර් තමයි ට්‍රේනින් ඩිවිෂන් එකේ ඉන්චාර්ජ්. එහෙම නැත්නම් අර කෝඩිනේට් කරන මිස්ටර් කියන්න මේ විශාන්ති. හා? ඔයාලා WhatsApp group එකක් තියෙනවා. ඔයගොල්ලෝ ඉන්න මම නැති. ඒකේ මාක්කයි දාලා මේ ඔයගොල්ලන්ගේ choice එක ආයතනෙට කියන්න. අනේ විශ්වද? ඉතින් ඔයගොල්ලෝ ඔන්ලයින් කැමති කීයක් කිව්වද? right? Right, then what about your choice? Whatever it is. ඒක නම් හරි පොරලක් තිබුණා. ලෝ කරද්දී ඩිගල් කරන්න පුළුවන් නම් ඒක ඒගොල්ලන්ට හරි ඉම්පෝටන්ට්. මට ටිකක් hard. ඒක වල ඔන්ලයින් කරනකොට වඩා ෆිසිකල් කරනකොට face to face එද්දී ගන්න එෆෙක්ට් එක ගොඩක් වැඩි වෙනවා. නමුත් මම ඒක ඕකේ. මම කැම්පසින් එක ගන්න ටියුටර් කරේ ගන්න මම. රාමාවු වැඩක් නෙවෙයි. ඒගොල්ලන් තියෙන බෙනිෆිට් එක වැඩි. තමයි ඒ වගේම ඉගෙන ගන්නදී මතක තියාගන්න තිබා ඉවා දුක් විඳින්නත් ඕනේ. ඒවා කිටිකාලීන දුක්. ආගාව නිසා මම කියන්නේ 5:20ට පටන් ගන්න කෝච් කියනවා. මොකද මම මේක ගන්න. සමුද්‍ර දෙන්නේ. ඊයේ කොළඹට එන්නේ. හා? ඒක වගේ එන්නේ නෑ. මේක එන්නේ මම දන්නේ නැහැ දැන් ටයිම් දැනුත් එහෙම වෙන්නේ නැති ෂුවර් එක. සාමාන්‍යයෙන් අතහමාර විතර වෙනවා. ඒක මේ ස්ටේෂන් එකේ බහැලා අලුත් කලේ පැත්තට වයින් දුවනවා. යන්නේ නැහැ දුවනවා. කොහෙද? ලෝකෙට. හරි. 5:20 ස්ටේෂන් එකට එන්න. මෙතනින් 5යි කාලර් නැගිටලා බෑනේ. නැගිටින වෙලාව ඒවා ඔයගොල්ලෝ මෙතනමයින් කරනවා. ලෝකෙදී ලෙක්චර්ස් කරන්නේ 5ට. ඒ වුණ විට තෝරන ගිහිල්ලා දැන් ටයිම් ෂෙඩියුල් වෙනස් කරනවා දැනන් දෙන්න. ලොකු වෙනසක් වෙන්න බෑ. එදා සතුන ගාලු කුමාරී කියලා ඒවා ගිහිල්ලා ඔය කියන සමුද්‍රෙම තමයි ඉතුරු වෙන්නේ 5:40 එනවා. ගාලට යද්දි 8:35 ෂෙඩියුල් ජීවිතේ යන්න විතරයි. නාමයේ විතර ගෙදර යනකොට ඒවා ඉතින් කෝපාඩම් කරන වෙලාව නැත. මොකද කරේ? ගල්වා පොච්චි ඉන්න කවුඩ් එක දිහා. සමහරු විශේෂයෙන් ඔයගොල්ලෝගේ නේ ඔය වයස ගාය ඔයගොල්ලෝගේ අය මේ මාර්ගයේදී හරියට හස්පන් මෙහෙ කන්නේ කියලා හිතුව වෙන්නේ නැහැ. ගොසිප්. right? තව කට්ටිය හිටගෙන ඕම්බි ගහන. පොච්චිගේ ප්‍රය දන්නේ. මම දන්නවා. මං ගිය අවුරුදු 4ක් හිටගෙන ඕම්බි ගහන. ඊට ඕම්බි ගහන්න පුතු හතරගේ මේක කියවලු. මොන් හිටගෙන ඕම්බි ගහනවා. හරිද? තව කට්ටිය අප කැරෙනකන් ගෝච්චි යකඩට ගගා සින්දු කියනවා. තවත් කට්ටිය හෙඩ්සෙට් දාගෙන සින්දු අහන. මම තෝරගත්ත හෙඩ්සෙට් දාගෙන සින්දු අහන ගොඩ. ඔය ලෝකේ යනකොට කල්ලි හැදෙන්න ඕන. ඒක යන්නේ. හෙඩ්සෙට් දාගෙන සින්දු අහන ගොඩ තෝරගන්න. ගිහලා මං ඇහුවේ මොනවයි හෙඩ්සෙට් දාගෙන. පෙන්නන ලෝකෙ විතර සෙකන්ඩ් අපරේ. හරි. ලෝකෙ කියවුවේ අහගන්න සෙකන්ඩ් අපරේ ගන්න එක. ලෝකෙස් නේ ඕන කැම්පස් එකේ ගිය කෙනෙක් දන්නවනේ. සෙකන්ඩ් අපරේ ගන්නවයි කියන්නේ. ඒ වගේ. මොකද ඉංග්‍රීසි කාලේ මතක් කරගෙන හිටන් දෙපා. ඒක හරියම ෂෝට් ටර්ම්. ඉවරිච්ච ගමන් ඊට අපිට ලොකු ලෝකයක් විරුද්ධ කරනවා. ඊපස්සේ පොඩ් පිට ප්‍රකාශ කරලා මම ඔයාගේ පහසුවට කරන්න මොකද හස්බන්ඩ් ඉතින් ඉන්න තමයි ඉඳලා ඉස්සරහට ඉස්සරහට ඉන්නේ සයින් කළා නෝ කොහොම වුණත් විසිකල් තරම් මේ ඔන්ලයින් වල ඔප්ෂන් එක හරි මොකද නේ අර මාස්ටර් there is another types of employment, right? That is casual employment. It is not a complex situation like earlier things, but it clearly says employment of worker not in employment of worker not in excess of 108 days in one calendar. That means it is not continuing more than 180 days and under the temporary base. But if it is continuous more than 180, different story. Casual employment. Now, the main features of that employment, there is no bound. Now, if you are a permanent employee, when there is a working day, can you stay in home? Why can't? If you obtain the approved leave, you can. Otherwise, you can't. But in case of casual, there is nothing like that. No
That means,
bound beyond both parties. Right? If the casual employee absent, there is no issue. Right? Only thing is you aren't getting salary, the daily payment. Right? And if the casual employee continues more than 180 days, he becomes a permanent card. Right? Continuous 180 days. Right? For the employee in casual, there is no beneficiaries like fixed term, permanent, season, right? Normally they are giving work under temporary basis. And another types of employments, casual is a very simple thing, right? Temporary contract of employment. Temporary. It is not a casual. Now, casual means he is working according to willingness of him. But temporary is a different story. Now, if you want to paint this building, do you need permanent garden? No. Right? Until finish the task, you can appoint temporary employee. Say, paying daily wage. When the work is over, there is nothing. That is temporary. But the casual is different. It is not having a clear task. They are coming and work various things according to willingness of the both parties. Fixed term, completely different. It is term is fixed, clear target, clear position, and clear place. Casual means there is no clear target, clear place, clear position. based on the requirement, appointing and pay. That's all.
That means,
Yes, Ahmed.
casual means that we work when there's a work available, no?
Work available, there is no clear target, just like fixed term.
Okay.
Right? Whatever the situation, it's not relevant to today's topic, but whatever the situations, you have to pay EPF, ETF.
The statutory payment is always involved, no?
Yes, statutory payments always involved for any position. You will learn about EPF, ETF Act during this course in broad way, entire act. I've just mentioned.
Okay.
EPF, ETF, gratuity, all these statutories you will learn during this course. Right?
Also, apprenticeship, will they be getting EPF?
Wait. My last point is that. My last point is that. Right? Apprentice. Right? There is a specific act for the apprentice. That is Apprentice Act. Normally, there are some organization, you know, the places called night and those things, right? ඕක ගෙදර ගිහින් බලා ගන්න. දැන් මං කියන දේ අහන්න. මොකද ගෙදර මම නැහැ. ගෙදර ඉන්නවා විතරයි. right? ඉතින් මෙතන මම ඉන්න නිසා කියන දේ අහගන්න. ගෙදර ගිය ඔය මං කියපු ඔක්කොම තියෙනවා. right? ඔයිට වැඩි දේවල් කියලා තියෙනවා. මොකද කේස් ලෝස් ඕගේ නැහැ. Apprentice mean there is no employer-employee relationship with the company. Right? Apprentice mean they have followed the course, right? Some relevant to some subject. Now they want to recover practical experience. To fulfill that, they come to any place. That is under Apprentice Act. It is not an employee or employee. Apprentice letter, EPF kata. හොඳ ප්‍රශ්නයක්. ගෝලංක කියලා එනවා. හා? මොකද දෙන්නේ? මොකද දෙන්නේ ජොබ් එකකටද? ප්‍රශ්න උත්තර දෙන්න ජොබ් එකකටද? ඉන්ඩස්ට්‍රියල් තමයි මං අහන්නේ ජොබ් එකකට දෙන්නේ. Is it job? No. What are you going to do as a company? Support him. Are you paying salaries for them? Mangahani salary kila manga huwe. Are you paid salary for them? No. No. Salary.
So, as an example, audit trainees and junior lawyers work under senior, those apprenticeships, right?
Yes, what is the question?
No, the example for the apprenticeship.
Yes. Whatever. එයාගේ ට්‍රේනින් පීරියඩ් එක මාස 3 ඉවරයි. තව මාසයක් ඉන්නවා. එයා බලෙන් ඉන්නවද? එයා බලෙන් තියාගත්තද? මාර වැඩන්නේ ඒක. ඔයා කියන්නේ කම්පැනි එකට අම්බලමක්ද? රික්වෙස්ට් කරන්නේ කවුද? එන කෙනා. පිළිගන්නේ කවුද? ඒ මොකක්ද ඒ වුනේ දැන්? මොකද? ධාරණයක් ගන්න හැදී ෂෝක් කොහෙද හරියන්නේ නැහැ. අනාගතේ වෙන්නේ කොහොමද? කවුරු හරි ඔෆර් කරනවා. ඔයා ගන්නවා. දැන් මොකද වෙන්නේ? බාඳිනවා. ඇග්‍රීමන්ට් එක. right? බලහත්කාරයෙන් දෙන්නේ. right. අකමැති නම් බඳිනවද? නැහැ. එහෙනම් දැන් අප්‍රෙන්ටිස් එක ඉවරයි. right? දැන් ඔක අම්බලමන්ත කම්පැනි එකක්ද? කම්පැනි එකක්. කොහොමද බලින් ඉන්නේ? ඉන්න බෑ. ඉන්නවා කියන්නේ මොකද්ද? නැතුව බලහත්කාරයෙන් තියාගන්න පුළුවන්. කවුරුවක්ද? බලහත්කාරයෙන් අතුලෙන්න පුළුවන් කතාවක්. right? That means end of apprentice is over. Now you join for the new agreement. There is no letter but verbal. Right? Huh? Verbally පිළි ඔප්පු කරාම උසාවියේ ඇයි දෙන්නේ? apprentice ඉවරයි. ඔයා වැඩ. අරහෙන් පඩි හරි මොනවයි සල්ලි ගෙවනවා. දැන් allowance නෙමෙයිනේ. ඔය apprentice ඉවරයිනේ. කොයි තේම තියෙන්නේ? ඔයා වාසියට කියයි. අපියෝ පිළිගන්න. allowance එහෙමයි කියන්නේ මරණකම් allowance ගන්න. එහෙම කොහෙද තියෙන්නේ? ඔයාගේ apprentice එක ඉවරයි. දැන් මේ allowance එක ගෙවලා ඉවරයි. right? දැන් ඔයා තවදුරටත් කන්ටිනියු වෙනවා. අවුරුදු employee. ආට ගෙවන්නේ allowance කියලා. ඔයා කියේ අපි කියනවා salary. පුරාණ නැහැ. ඇයි ඉවරයි මේක. apprentice period එක. යුනිවර්සිටි එකෙන් දීපු දුන්නේ සදාකාල නෙමෙයි මාස 3කට. ඔයා එයා තියාගන්නවා මාස 3 ඉක්මවා. ඇයි? වාට වැඩ කරගන්න ඕනේ. එහෙනම් ගෙවපන් පරි. වැඩි කරනවා කියන්නේ මොකද්ද? employee relationship. right? ඒ නිසා ඕක මම දන්නවා තැන්වල කරනවා. right? ඔය ෂේප් එකේ වැඩ ගන්න ක්‍රමේ. හැබැයි ෂේප් එකේ වැඩ අරන් පර්මනන්ට් කරන සිද්ධ වුණා ලංකාවේ තියෙන ලොකුම කම්පැනිස් දෙක තුනක්. පර්මනන්ට් කරන සිද්ධ වුණා. කොන්ට්‍රැක්ට් බේස් එකෙන් ඒව දෙනවා. right. එතකොට how much are you
Yes.
getting? Have you got everything?
Yes.
Right. Now, finally, I explained about the apprentice, and up to now, I have explained various type of employment. Everything is clear for all, both physical and online.
Yes.
Any questions? Any questions?
So there are some
Nothing.
other, sir,
Yeah. Yes.
there are some other seasonal
Seasonal, of course, I explained.
same.
But seasonal, I have explained, already explained.
Explain. Yes.
Right. Now, any questions? No, I am having a question. ඔයගොල්ලන්ට ප්‍රශ්න නැත්නම් මට ප්‍රශ්නයක් තියෙනවා. Right?
Okay.
මේ ප්‍රශ්නේ අපි කන්ටිනියු වෙන්න අරිමු. මේ ප්‍රශ්නේ ලියාගන්න. X Private Limited.
Done.
Samsung ගේ කඩේයි what's the difference between Samsung ගේ කඩේයි and X Private Limited?
So sole proprietorship and limited liability.
Of course. ඔයගොල්ලන්ට තේරෙනවද? Samsung ගේ කඩේ. How the liability?
Samsung.
Right? X Private Limited. Private Limited. That means it is registered as a company in the country, according to the Companies Act.
Separate
Right.
legal entity.
Right? Legal liability goes to this company, not the Samsung. Right? It is X Private Limited. Silva. Ahmad කියලා දාන්නද?
That's
නෑ අපි Silva කියලා දාමු. Right? Silva is the purchasing manager, supplies manager. Right? And Ahmad, give me a name of the lady.
Chandrika.
Chandrika. Good. Okay, දාලා ප්‍රශ්නයක්. අපි දාමු සුනීතා කියලා. Sunita. Have any Sunita?
ගෙදර පරණ සර්වන් කියනවා.
Huh? Seven ගෙනවද? එහෙනම් අමතක වෙන්නේ නැහැ. Right? Sunita. Right? In this example, Silva's wife is Sunita. Right? Silva's wife is Sunita. She is giving meals for this X Private Limited every month. I mean, daily. He's getting money every month. Lunch and dinner. Right? And Kanti telephone operator, receptionist. And Samantha accountant. This company having around 500 who is working day and night service. It's a factory, day and night. That is why the company needs to supply lunch and dinner for their crew. So, using open tender method, Sunita selected as a supplier. Anyway, Sunita is the wife of Silva. Right? All right. Now, issue is this. Suddenly, about 80% of the employees were hospitalized, and doctor's report says food poison. Top management of the company really worried. They checked who are the direct and indirect responsible for this. Of course, she is directly responsible who supplied the goods. And he is the supplies manager. His duty is there to do the supplies to the company. He is the reception and telephone operator. She is handling coordinating part. And Samantha, what is the name I mentioned? Sampath, no? Anyway, whatever it is. Right? He is the accountant. He is also liable. Right? According to the company, I don't know. Right? The company decision was terminate or Silla is in probation. Silla is probation. Accountant is seasonal. He is on fixed term. No. Accountant fixed term. Kanti seasonal. Silla permanent, but permanent card, but under probation. Right? නම් ටික අමතක වෙන නිසා මාත් ෆොටෝ එකක් කරන් තියාගන්න. All are terminated without inquiry. Without inquiry. Right? That's why I think good position.
How long
It doesn't matter, but anyway, say 1 year's time, 2 years' time, no problem, it's not a matter. Right? Sunita supplies meals to the company. But
was approved by the board?
yes, only thing is supplies manager is yes, that's a good question. Right? It is approved by the tender board. But only thing is he is the chairman of he is the member of the tender board, not the chairman. That's also a good point. Silva is the member of the tender board. Now don't think about the tender process, right? Think about in labor law part, right? Without inquiry, all are terminated. Quickly suspended the supplies of Kanti, right? No need the answer today. Again, next day, I want your answer in one word. Yes or no? Okay. I can ask. They have terminated. Whether it is legalized. Yes or no?
And if it's at least nearly 1 year, payment has been done. You may have also know that
Okay. Consider she has supplied meals more than 180 days. More than 180 days. මේකේ ඩිෆරන්ස් එක මම අනිත් දවසේ කියලා දෙන්නම්. 180 නේ මෙයා 1080 දුන්නත් වැඩක් වෙනවද කියන එක මම කියලා දෙන්න. right? මොකද මෙතන තියෙනවා සුවිශේෂ තත්ත්වයක්. පොසිෂන් එක නෙවෙයි. right? ඒකත් නේ. right. අපි අනිත් දවසේ කතා කරමු. We'll discuss in tomorrow next day contract of service and contract for service. right?
අපිට රීකැප් එකක් කරන්න පුළුවන් මොන මොනවද ඩිස්කස් කරේ කියලා.
For today.
Yes, only the headings, the topics.
Today.
Yes, yes.
Today, of course, we have discussed types of employment.
Only
Permanent,
that.
probationary, only that. Permanent, probationary, temporary, fixed term, casual and
Apprentice.
yes, apprentice.
So the acts we discussed today only this.
No, really, we can't say we have not discussed any entire act. We discuss some relevant parts of the various acts to fulfill the knowledge of this topic. Not the entire act. Because we are talking about the types of employment. When we are discussing that, we need some section of the various acts, like Termination Act, Industrial Dispute Act, Shop and Office Act, all those things relevant for this topic. Okay, Ahmed?
Okay, sir.
Right, in that situation, I am going to conclude the lecture today because I have completed the types of employment. Now, remember that example question. Next day morning, I need the answer from you. Again, yes or no. My question is, all are terminated, whether it is legalized. Right? දැන් උත්තරේ එපා. ඊළඟ දවසේ උදේ කිව්වම ඇති. Yes or no කියලා. Next day, I will discuss with you contract of service and contract for service. Another very important topic for the labor law. Okay, Ahmed, and all other, not only Ahmed, all other participants. Are you with me, participants? Amali, can you hear me?
Yes, sir.
You got everything?
Yes, sir.
I can't hear your voice, Amali. You also from UK?
No, sir.
From where are you?
I'm from Tangol.
Ah, very short distance. I thought you are also from UK. Right, anyway, Amali, you like to have a online or physical?
I like online.
Online. I think Ahmed, you like for the physical, no?
I like physical because I'm now worrying about why I'm not in Sri Lanka to attend the lecture.
So why don't you come to every Sunday to Sri Lanka?
It can NILS provide tickets for me, then I can come and go.
You discuss with the Niles. Sometimes it may be provided. Okay. Okay, thanks all. Conclude the lecture now.
How many are there, sir, in the physical class you have now today?
I can turn the camera. You can see. You see, huge crowd.
There are people, right? Okay.
Why not? Otherwise, to whom should I speak? Okay. You can select anyone and talk.
I have to turn
Right.
on my camera, no?
Of course, I can see your face. Ah, right. Okay, Ahmed. Thanks for everything. I'm going to conclude the lecture now.